You got it. Now I'm going to go back into hiding.
Okay, yeah, I'll see you in a little bit.
All right,
Thanks.
sounds good.
Good morning, guys. Sorry for the delay. Our folks are assembling, so we'll be starting relatively soon. Thanks for your patience. Okay, I see a few faces, 4, 5, 6. I only see 6 faces, so we can't start until I can see 7 committee members in the live Zoom screen. There's another one, still buttoning his lovely shirt. Good morning. All right, we have a quorum, so we will get started with introductions, and I expect that others will be popping in as they find the link and get themselves organized this morning. Good morning and welcome to the Joint Standing Committee on Health Coverage Insurance and Financial Services. We have a large number of work sessions on the docket for today. And so without further ado, we will start with committee introductions, beginning with Representative Connor.
Thank you, Madam Chair. Good morning, everyone. My name is John Connor. I represent House District 58, which is part of Lewiston.
And Representative Arford.
Thank you very much, Madam Chair. And my name is Poppy Arford. I represent District 49, which is the western part of Brunswick. But I want you to all know I have Carrabassett Valley, Bigelow Mountain behind me on the screen.
One of the most wonderful places on earth, for sure. Okay. Representative Blyer, go ahead.
Thank you, Madam Chair. Good morning, everyone. My name is Mark Blyer. I represent District 22, which is Leamington, part of Buxton, Standish, and Limerick.
Madam Chair, can I have one more follow-up question?
Okay. Thank you, Representative Blyer. Representative Malorano.
Good morning. My name is Gina Malorano. I represent House District 62, which is part of Auburn.
And Representative Brooks.
Good morning. My name is Heidi Brooks. I represent House District 61, which is part of Lewiston.
Representative Morris.
Good morning. I'm Representative Joshua Morris. I represent House District 75, which is Turner, Leeds, and Livermore.
Senator Stewart.
Morning, everyone. I'm Trey Stewart, State Senator in District 2, which includes 51 communities in Southern Aroostook and Northern Penobscot counties, including the town of Smyrna.
Senator Brenner.
Thank you, Madam Chair. My name is Stacy Brenner. I represent Senate District 30, which includes Gorham, most of Scarborough, and part of Buxton.
Representative Tepler.
Good morning. My name is Denise Tepler. I am the state representative for House District number 54, which is all of my sweet town of Topsom. And I am the House co-chair of the committee.
And my name is Heather Sanborn. I represent Senate District 28, which is half of Portland and half of Westbrook. And we are assisted today by Colleen McCarthy-Reed and a new person filling in as our clerk. And I'm actually not sure who it is. I think it was in my email, but I haven't read it.
It's Sabrina Carey from the ENR committee.
Wonderful. Thank you for joining us, Sabrina. And I know you and Senator Brunner have worked together. So glad to have you helping us out now that Christian has moved on for the year. All right. So without further ado, the first order of business this morning is that we are going to postpone the work session on LD 1463, which is Representative Tepler's bill on the health insurance assessment to fix the family glitch. We just had too much else to caucus today. And so with that stated, Representative Tepler, go ahead.
Thank you, Madam Chair. I move we table LD 1463 for a later date.
Thank you. Is there a second? Seconded by Representative Brooks. And so we'll vote on the tabling motion with our real hands in the window, as we do in this committee. All those in favor of tabling LD 1463. Great. Thanks, everybody. Appreciate that. As you can see, our caucus ran a half an hour late, even without needing to talk about that particular bill. So that was why we wanted to take this approach. So next up on our process for today, just to give everybody who's listening a sort of a roadmap of where we're headed, we plan to work on the telehealth bills first this morning, then plan to pick up the easy enrollment bill 1390, followed by the universal healthcare bill 1045, followed by LD4 pharmacy bill, followed by the occupational therapy bills, followed by the which is 31 and 1646, followed by the dental licensure bill, which is 1660, followed by the oral surgeon licensure, which is 1629. Then we will pick up retirement savings, which is 1622, a bill on step therapy and prior authorization for certain types of medication, 1268, a concept draft provided by Representative Warren, 738, the Employee Health Commission, 1311, and an insurance bill for multifamily residences, which is LD 1661. So that's our plan for the day in order. At some point, obviously, we will take a lunch break and perhaps other breaks as we proceed, depending on how robust and lengthy our discussions become. But I do anticipate that we may be able to vote on all of those bills. I'm hopeful we might be able to vote on all of those bills today. So our plan is to first work on the telehealth bills. And so Colleen, I don't know, do I need to like open a work session on all the LD numbers, like read them out?
Sure. Do you intend to vote on all of them? I guess probably yes. Probably should open a work session on all of them, and then we can figure out how to deal with all of them once you have your discussion, I guess.
Great.
Yeah.
So I'm going to open a work session on the following bills: LD 1681, 323, 333, 649, 791, 849, 1007, 1194, and 1361. You can note that I've held 863 aside. We're not opening a work session on that just yet. It's the SciPac bill. That's the practice compact for psychologists. We'll pick that up after we deal with the core of the other bills.
I think you also want to include LD 791, which was the concept draft for telehealth as well. So
I think I read that out. Yep.
Oh, you did? I might have missed that. So
Yep.
Great. That one.
Okay.
Perfect.
So Colleen provided us with a chart that attempted to sort of answer some questions and also lay out the answers to those questions provided by all the different bills. And there's a lot here, as you can see. There's, you know, an enormous number of different bills and proposals, and a lot of them touch on a lot of different topic areas. So what I have tried to do in order to sort of assist the committee, and I'm hopeful that it will assist the committee, is that with Colleen's help, I drafted an amended version of 791. Colleen drafted an amended version of 791 at my request that captures at least one way of proceeding with telehealth, and would be kind of an omnibus that incorporates a lot of the different issues that were discussed at the public hearings. Obviously, it only incorporates like a particular answer to each of those questions, but I thought rather than discussing the chart, it might make sense to just start with the amendment and have Colleen kind of walk us through the amendment as a starting place that simplifies what otherwise could be a really difficult discussion. Does that sound okay with everybody as far as where to start on this process? Okay. All right. So Colleen, could you share that draft amendment for us and kind of walk us through the different pieces and how they answer the different questions that we've kind of talked about?
Sure. I think everybody can see this. Is it big enough? So, and this is Senator Sanborn said, uses LD 791 as the vehicle for the framework of your discussion. It separates the proposal into two parts. Part A would make changes to the existing provisions in Title 22 and 24A related to services delivered through telehealth under main care and under under health insurance. And then Part B would incorporate some of the suggested changes related to licensing board authorization for telehealth services for various healthcare professionals. So just really quickly, Part A, and one of the primary sort of technical things is to try to make the definition of telehealth and related terms consistent between Title 22, Title 24A, and then a proposed definition of telehealth as it would apply to in the various chapters related to licensing of health professionals. So for purposes of sort of moving through this and having everybody be able to see, I included all of the text of the current law in Title 22 and 24A, and so you can see where the changes are made. In the Title 22, there are some changes to the paragraph D, telehealth, making some changes to be consistent, and Senator Sanborn suggested that the definition that's proposed in LD 1681, which we're going to talk about, seemed to be the most appropriate definition to use moving forward. So the changes in paragraph D that you'll see here are consistent with the proposed definition included in LD 1681. So just clarifies or would define telehealth as the use of information technology and including synchronous, asynchronous encounters, store and forward transfers, and telemonitoring. And it removes sort of specific references to the setting where the telehealth services are delivered to the patient, where the patient is, and also removes some of the existing restrictions in statute as it relates to particular types of technology, like the use of telephone only, for instance. So those are the definitional changes in Title 22. And then the additional change in Title 22 incorporates a provision that was included in one of the bills, LD 323, clarifying that for the purposes of main care coverage, both telehealth and telemonitoring services, that patients may provide verbal, electronic, or written consent. My understanding is that's something that's currently being allowed under main care, and there's a suggestion that that should move forward. So those are the changes related to Title 22. Then with regard to Title 24A, and these are the provisions that govern how health insurance coverage for telehealth services is determined. As I mentioned, part of the intent of the amendment is to make the definitions consistent. The Title 24A provisions did not include a specific definition of synchronous encounter and asynchronous encounter that was included in the Title 22 definition. So that has been added here. And again, the corresponding changes to the term defining the terms telehealth and telemonitoring that I just mentioned are also made, as well as sort of removing the restrictions on the method, whether it's telephone, fax, email, text, or texting. With regard to the subsection 2, which governs parity for telehealth services, you might recall that some of the proposals that were brought forward would require payment parity to continue after the end of the current emergency. Under the current law, while parity for coverage is required, there's no requirement that providers be reimbursed at the same rate. And subsection 2, as Senator Sanborn has presented it, would not require payment parity, but would add this clarifying sentence that carriers are required to, or may not deny coverage on the basis that a service is provided to telehealth. Under the existing statute, it says if the healthcare service would be covered if it were provided through an in-person consultation between an enrollee and a provider. And this additional language underlined would be added here. And as long as the provider is acting within their scope of practice and in accordance with any rules adopted by the board that issued the provider's license related to standards of practice for the delivery of a healthcare service through telehealth. And this in part, I think, recognizes the next piece of the bill, which is the authorization for each individual licensing board for health professionals to define by rule sort of standards of practice for how telehealth services are delivered. The next change is adding this language here in paragraph D. This was a provision that was included in, I think, LD 333, brought forward by Representative Hymanson, adding language to the current law that prohibits carriers from making any restriction on prescribing medication through telehealth by a provider whose scope of practice includes prescribing medication. And again, the restriction cannot be more restrictive than any requirement in state or federal law for prescribing medication through an in-person consultation. So making clear that carriers have to use the same standards as it relates to prescribing medication. It does remove the provision in current law that restricts or provides a framework for when coverage is required for telephonic services. And the last provision that would be added to subsection 10 in the insurance code provisions is just language that clarifying, which I think there is an existing Bureau of Insurance rule related to network adequacy, which refers specifically to geographic locations of providers and having them available, but this would put in statute a statement that the availability of healthcare services through telehealth may not be considered for the purposes of demonstrating the adequacy of a carrier's network. And then it cross-references both the statutory provision related to reasonable access and the Bureau of Insurance's rule. So part A is the changes to the existing statute, and then part B really just incorporates all of what was included in LD 1681, which was the bill brought forward by the governor. in the administration, which would add language in each of the sort of licensing chapters for health professionals related to telehealth services. So it incorporates really all of LD 1681 as drafted. The definition of telehealth services, and again, it's meant to be consistent with the previous definitions I mentioned. It would state that persons licensed may provide telehealth services as long as the licensee acts within the scope of practice in accordance with any requirements and restrictions imposed by this section and in accordance with standards of practice. Licensees must comply with all state and federal confidentiality laws. All of the rules and laws governing professional responsibility and generally accepted standards of practice apply when providing telehealth services. And then each of the provisions requires the board to adopt rules governing telehealth services. And the rules must establish standards of practice and appropriate restrictions for the various types and forms of telehealth services. The rules are designated as routine technical. And then there's corresponding, the same language is enacted in all of the licensing board chapters. One of the things that's not addressed in this amendment, which I wanted to raise for the committee, is sort of the timing potentially for when the rules are adopted. This requires each board to adopt rules governing telehealth services, but it doesn't set a specific time frame for those rules to be adopted. And just to be aware that the current executive orders that govern telehealth services remain in effect until rescinded or until by the governor or until the state of emergency is terminated. And the committee may want to consider either putting into the law a specific timeline for when these rules should be adopted, or perhaps thinking about the potential gap, if you will, for when the executive order might be lifted and when these rules would go into effect. So I'm happy to stop sharing so you can discuss. I can pull anything back up for you.
That'd be great.
This or any of the other documents as well. Thanks.
Thanks, Colleen. So I just wanted to flag a couple of issues that I think, well, a couple of issues that are not addressed by the amendment, aside from the one that Colleen just pointed out with the timing piece. One is sort of making it easier to get a license if you're an out-of-state provider who wants to provide telehealth. There were a number of bills on that topic. And my suggestion was that the committee deal with that question through our other bills on licensing. So for example, the SIPAC licensing bill, the occupational therapy licensing bill, and the licensing by endorsement kind of concept, as well as the flexibility in like the dental licensing bill 1660, I think it is. So my suggestion was that any sort of discussion about making it a little bit less rigid to get a license should happen in those other bills. So I haven't included anything on that topic in this particular omnibus. The two big questions I think that we heard different varying answers to over and over again during our telehealth day were, what do we do about this telephonic provision in the insurance section that allows insurance companies to deny coverage for telephonic encounters in certain situations? And what do we do about payment parity? I think those were the two big questions. The answer contained in this draft that I thought would be helpful for the committee to just kind of start from a jumping off place. The answer in this draft is that for the first question about telephonic encounters, is that it should really be up to the boards of each different professional licensure to put any guardrails that need to be put on what telehealth should look like. It should be a profession by profession determination in their rules if there need to be guardrails. And then that can be revisited over time as the profession develops or as the need for or use for different technologies might be appropriate or not appropriate. It seemed like it needed to be very much an individual determination, and that I wanted to take that determination away from the insurance companies, which is where it is today in our statute, in the absence of the pandemic, and put it back in the hands of the folks who are in charge of ensuring that our medical professionals are acting, in an ethical manner and in the best interest of their patients and in accord with their scope of practice. So I think the way that I've recrafted the definition to line up with the governor's bill proposal in 1681 just sort of takes out this question of audio only, takes it away from the insurance company, and instead says, if you are providing services in accordance with the rules established by your licensing board, then the telehealth parity of coverage rule that's been in our statute for a long time applies. And the need that we heard from Lisa Harvey McPherson, for example, to document every single time that the internet failed and you had to pick up the phone and finish an encounter by telephone, that would go away under this draft. So I guess just on this audio only telephonic question, if the committee can kind of focus on that piece, and then I'd love to get feedback and hear from folks on the committee as to whether we're on the same page with regard to that solution to the telephonic piece. Representative Morris.
Yes, thank you, Madam Chair. So I just want to make sure I have clarity and understand what your position is on the telephonic piece. It's to put it into the rules and let each individual profession decide which. Now, would those rules be technical, or would they be more substantive?
They're technical.
Technical, okay. But it would be up to that, what they felt was in the best interest of the patient, and what the patient wanted to do ultimately is what your line of thinking is on that piece.
And then it might be a really different answer for like the Board of Psychology than it would be for like dermatology, just to give an example, right? If I can't see your skin, maybe I can't, actually do dermatology. So yeah, so okay. Those were kind of the two examples that I had in mind.
Okay. I just have one more. Okay, so Colleen just sent us the amendment.
Okay, I apologize.
I did. I just emailed it out to everybody because I hadn't had a chance to upload it. Yeah.
Okay, so I guess my other question on this is, obviously this is encompassing everything but 863 is my understanding. Or so I guess what, just from a procedural standpoint, is just to kind of discuss this today and then probably not vote it today.
Yeah, I would love to be able to vote it, but maybe after lunch, so that folks got another shot to kind of look in the weeds about it. But just because of where we are in this session, I mean, that's why, and I apologize I didn't get the draft out earlier. It's just, Colleen and I were working on it until this morning. But I think that my hope is that if we can have a discussion about the substantive questions that it answers that I think are controversial or might have disputes over, then we can always wordsmith it if we find something as well. But if we're on the same page with regard to the substance, then we might be able to get it done today. It's why I wanted to pick it up first when the committee was fresh, and also when we would have time potentially to talk about it with each other over lunch as well. Representative Tepler.
Thanks, Madam Chair. I just want to be certain, and this is something I got a little confused about reading Colleen's chart as opposed to the amendment, that the definitions in Title 22 and Title 24A were consistent with each other, and that we were adopting the new definition based on synchronous and asynchronous services for both titles.
Mhm.
Is that correct?
That's the intention, and the intention is to use the definition proposed in LD 1681 as the model. So some of those terms were already included in Title 22, for instance. Asynchronous and synchronous were defined in Title 22, but weren't specifically defined in Title 24A, even though we use those terms, we just didn't define them specifically. So the intention is to make the definitions consistent, recognizing that in Title 22, we call individuals patients, and in 24A, we call them enrollees. So there are some, they're not exactly the same, but the substance is intended to be consistent among all three parts of the bill, if you will.
Thank you.
Which is a thing we've never accomplished before in telehealth. So this is definitely an improvement, I think. So the other controversial issue that I think is captured by this amendment, mostly in its silence, is around payment parity. So Maine has long had a mandate for coverage parity with regard to telehealth, and under the executive orders during the pendency of the emergency, there was a requirement for payment parity as well. The bill comes down, the draft amendment comes down on the side of not mandating payment parity. And let me just, again, that's sort of just my proposal to the committee. And so let me kind of articulate why that's the case, and then open that piece of it up for discussion by the committee as well. So I think, the question is, should insurance companies pay providers at the same rate in all cases for telehealth services as they would for those same services in in-person encounters? And I think this is a matter under our current system that insurers and providers have to work out, because we still have a private insurance contract-based reimbursement system. And there may be circumstances where value-based models or bundled payments rather than fee-for-service are desirable, and a mandated payment parity could potentially get in the way and interfere with the development of that innovation. It could also strip telehealth of any ability to provide cost savings to our system. And it's important that we preserve the ability for us to utilize telehealth in appropriate ways to provide cost savings. And as you guys know on this committee, because I say it pretty regularly, that in my view, the legislature should not set reimbursement rates in private insurance in some areas unless we set them across the board. I'm happy to do that, but I don't think that the providers would be happy if I did that. So it's not the system that we have yet. And so we should stay out of it. So my suggestion would be that we would let the current executive order with regard to payment parity expire when the emergency ends, and that 24A, the insurance title, would remain silent as it is now with regard to the calculation of reimbursement for services provided via telehealth. So that's my take on the matter. Let's open that piece of it up for discussion from the committee. Representative Morris.
Thank you, Madam Chair. No, I am in full agreement with you on the payment parity piece. I think it, as you articulated, I think that the key piece of telehealth is that it is an opportunity for folks to be able to have that service provided less expensively, and I don't really want to get into a position where, like, as you say, we're regulating the rates and so forth. So I am in full agreement in letting that expire with the state of emergency. So as far as that piece goes, I think our side would be good.
Okay. Others who want to weigh in? Representative Matheson, go ahead.
Yes, thank you, Madam Chair. So I will support this, but I will also say that I don't necessarily agree with it. I don't think that most providers have found that telehealth, when they have a brick and mortar situation, that their costs have gone down and that the service is anything different through telehealth. So this will be top of mind for me in the future, but I understand how insurance is run right now, and I understand how the legislature has a responsibility to keeping costs for health insurance for consumers at a minimum. So I will support it, but it will be top of mind for me whether or not practitioners, private practitioners, actually have the ability to negotiate their provider relations and their cost structures, because that has not been the experience of a lot of my integrative practitioner constituents, that they haven't actually been able to negotiate their payment plans. So this will be top of mind for me. Thank you.
Representative Tupler.
Thank you, Madam Chair. And I just want to sort of reiterate in different words Representative Matheson's concerns. I don't think that this bill is the place to resolve the issue that independent practitioners face in dealing with the idea that they can or cannot, because they have little clout, negotiate payment with insurers. And I do think, though, that it is an issue that this committee may look to tackle in the future if we find that there is a lack of work on the part of the carriers in really being realistic about negotiating with independent practitioners.
Representative Arford.
Yeah, thank you, Madam Chair. I just want to quickly state that I support this. I think it's wise and equitable at this point in time, as we are still in the emergency state, and we have had very little direct comment from patients on any of these bills, and we simply don't know what value they will find in these services and whether or not patients will deem that they want to pay the same amount. They want their insurance carriers to pay the same amount for telehealth services as in-person services. So I think we need time to flesh this all out, and I appreciate your including this in your draft amendment.
Thanks. Okay, so there are a number of other questions, I would describe it as, that are answered by the amendment that I wanted to flag for folks, but I don't think they're terribly controversial, but I just want to kind of list them off as a reminder. So one of them is sort of this question about what is needed to document patient consent for telehealth in main care in particular. So I've included that language that was in LD 323. I thought that was helpful. Just raise your hand at any point if there's issues with any of these pieces. The question of prior authorization or different utilization review for telehealth was raised by LD 333, but our statute is actually already pretty great on making it clear that you can't have different utilization review metrics for telehealth than you would for in-person services. So I felt like the language that was proposed in 333 wasn't needed. And Colleen provided the full text in the amendment. There's the full text of our current law that talks about utilization review has to be the same as it would be. So I didn't include that, any change there. There's a piece on the ability of whether insurance companies could limit the ability of prescribers to issue prescriptions via telehealth. And my leaning here again was that it should be up to the individual boards of licensure or state or federal laws to make rules about who can prescribe and when, as opposed to it being a question for the insurance companies. Poppy, did you have your hand up for a new question? You're on mute. You're on mute. You're on mute.
Sorry about that. do you want us to comment now as you go through it?
Yeah,
or
go ahead.
Okay,
Yeah, go
so regarding what you just mentioned, which is number 6 on page 2, consent for telehealth and telemonitoring services, what I would suggest that we do there to further change that, to further amend that, I think that I do have, and I've expressed this all along, concerns regarding opening up audio telehealth services to at the same level, I guess, parity of coverage with video and in-person services. And one of the ways I would become more comfortable going forward with that was if that when a patient was asked or was scheduling a visit and asked if they would like a telehealth visit, that it was documented in their electronic medical record or in their record, which is nowadays everybody has electronic medical record, that they, if they're giving it verbally, that at the very least it needs to be documented that they are giving it verbally, that they're giving it, because if it's written, you'll have documentation. And if it's electronic, I'm also assuming that would be a form of documentation. And also that at the time that this occurs, that if in fact the patient is going to be charged for this visit, that they be notified of that, that this will be a charged visit. Patients historically and traditionally have received audio services without any charge. So this will be a big game changer, and especially going forward in the ways in which the provider industry figures out to use this new basic line of business for them. So I think that at the very least, it needs to be documented if they verbally, and they also need to be notified at that point that this will be a charged service. If it's possible to provide the cost, that should be included, but I understand at this time that may not be possible. So that would be, if possible, provide the fee, but definitely that they be notified it will be a charged service. If it is, I mean, if they are charging for it.
Senator Brenner.
Thank you, Madam Chair. Representative Arford, I hear your point, but I'm wondering if someone is scheduling a visit at a set time with a provider, if that scheduling is consent enough for that patient to understand that they're going to be charged for the visit.
Absolutely. From my perspective, thinking about what people have reported to me in my own personal experience, it would not be enough. Specifically, and especially because this is really a new line of business for the provider industry to be able to charge for audio only services. And patients will be, many patients, especially elderly people and people that are simply not accustomed to talking about whether or not it's a charged service, will be blindsided by it. That's my sense of this.
So I just want to clarify what the current law is. The current law is that insurance companies can deny coverage for audio only visits, but there's no prohibition on any provider charging for an audio only visit except what's in insurance contracts. And if you don't have insurance, none of those apply to you. So our current statute actually is less protective, I think, than what we're asking the licensing boards to do, which is to take a hard look at this and determine what sorts of ethical and professional regulations should be put in place on a profession by profession basis. So with all due respect, I think right now providers could be nickel and diming consumers, but they're not. And they haven't been during the pandemic either. So I think that the question of whether sort of follow-up calls or informal calls are going to get charged for is something that we can deal with down the road if it starts to happen. But I asked that question specifically of the insurance companies, whether they were seeing nickel and dime kind of things being charged for that wouldn't have been charged for before the pandemic. And they said no, that they weren't seeing that. Representative Morris.
Oh, yes, sorry. Thank you, Madam Chair. I know Representative Quint is in right. I think she's right now over in the attendee space on her phone. And might want to
bring her in. Yep.
Yeah.
Oh, maybe I can rename her, remove her, or allow her to talk, but I don't seem to be able to bring her in. Colleen,
Yeah.
can you see how to bring her in? I don't know why I can't bring her in.
If you click allow her to talk, that brings her in.
Oh,
in the
okay.
phone, in like the phone.
Oh, in the phone version. Great. Thanks for letting us know, Representative Morris. Representative Quint, good morning. Welcome.
Good morning. Sorry about this. I'll be getting in later today to Augusta once I get my rental. But yes, I actually, can you all hear me okay?
We sure can. Yeah, it clears it
Okay,
out. Go ahead.
Wonderful. Okay, I do share some of the concerns that Representative Arford brought up, mainly because, and this obviously is because of the area that I'm in, but often people will call the doctor's offices and have conversations and they've never received bills before. And so since I think some of the requirements surrounding this are changing, the notification that they would be getting billed, because I think it would be something new to them, or if there was something that was sent out by their providers or their doctors, just something letting them know that in the future their phone calls could be billable, because they haven't been billable in this area really concerning healthcare. So that's just one concern that when Representative Arford brought that up, I am in agreement. It could be just a situational area, and I know downstate it might be much different because people are used to being billed more for the phone calls and that sort of thing. So because they've done a lot of their care, over the phone. So it is a concern of mine. So I don't know exactly how to address that, but it is something that I know in my area some of the older folks may be surprised by. So I just wanted to throw that out there. Thank you for bringing me into the committee.
Thanks very much, Representative Quint. Representative Quint, do you want to take a minute and introduce yourself?
Yes, hello, my name is Tracy Quint. I represent House District 144, which is 13 communities in Aroostook County.
Thanks. Okay, is there further discussion on that topic?
My only thought is that it seems like if we were going to further amend this, that would be a reasonable place to do it under number 6, because we're talking about a communication that would happen between the provider organization and the patient regarding scheduling, and that would be the time to let the patient know it would be a chargeable service, as well as to make sure that if it's done over the phone and there's no written, that it could occur that a patient could not understand. This is very new for people, and that they might not understand that they're actually choosing this service. And
okay,
so to have that in writing, that they have actually stated that this is the service that they prefer, I think that actually protects the provider, and it allows for the patient to further understand what the decision is that they're actually making.
So number 6 is about main care. I think if I'm clear on what you're talking about with regards to number 6, and main care consumers or patients, enrollees are generally not charged anything for covered services.
So I would assume what my thinking is that however that is worded there would be global. It would apply to all patients, whether they have wherever we could put this in the bill. And again, this is my first time seeing this bill. I haven't even had an opportunity to read through it. So I'm not sure where else that could go.
Yep. So Colleen just suggested that one option might be to add the language in the rulemaking for boards to address the ways in which patients would consent and would be aware of sort of billing practices. And so we could make that a task for the boards to make clear rules around as part of their rulemaking. Because again, this might be very different with regard to mental health counseling or nutrition counseling, for example, where that is the service, the talking is the service, versus a surgeon where the talking is probably not the service. The cutting is the service, or the sewing you back together is the service. So it makes sense in cases like that where there's a different answer for different professions to leave it up to the rulemaking, in my view. But that was Colleen's suggestion, which I thought was a good one. So I just wanted to throw that out there. Does that sound good, Representative Arford?
I appreciate Colleen's suggestion, and what I would be comfortable seeing is something in addition to that, which is a global guardrail that applies to all the boards in the way when they do determine what the rules will be for their profession, that they will have to include some form of notification at the time the service is delivered for audio services that have not previously been, we could even be very specific, for services, audio services that have not previously been delivered as a chargeable event. That I'm thinking about, and we don't know where the industry is going to go with this new line of service over time. We don't know where they're going to go, but we can assume that they're going to figure out ways to encourage their, to enhance their bottom line, because that's the nature of business. So if coverage, after hours coverage, if some practices determine that they are going to start billing for a service which has traditionally, historically been non-chargeable, then if someone calls in, they need to be told that this is now a chargeable event and be given the opportunity to not go forward with it if they don't feel comfortable or have the ability to pay for it.
Representative Tepler?
Thank you, Madam Chair. I'm having a lot of trouble understanding the what if that Representative Arford is presenting, because as I heard from Representative Evans, he is, as a general surgeon, given a total fee for his service as a general surgeon, which includes, I assume, pre-op evaluation, the operation itself, and post-op checking on the patients. And so unless, because we're talking about boards setting up rules, not insurers setting up rules about that coverage, I guess I just don't understand the situation in which that charge would be confusing to a patient. I mean, generally speaking, we're talking about either nutrition services which might be provided, or dietitian services that might be provided, or mental health services. And if you sign up for a telephonic service of that type, you know that that's how you're receiving the service. I don't get the what if, because sort of the new part of what I understand the provider industry, as you termed it, Representative Arford, is working with, is the issue of all telephonic service as provided by the for-profit organizations. And those are separate and in and of themselves, and not included in sort of what we're thinking about, like with a 5-minute follow-up call from a doc. I don't think that if I'm charged for an office visit and I have a lab test and my provider calls me with the results of that lab test, I don't think that that's something that I'm going to be charged for ever. And if I am, then my reaction is, let's deal with that when that happens, because right now that's a big what if.
Could I respond, Madam?
Sure.
So I think that this whole bill is filled with a lot of what ifs, because we're going into an area, although we have had services delivered during the pandemic, it has been delivered during an environment where people were not able to leave their homes safely. We're not able to travel safely. And as we head back out into what we hope will be normal time, there's so many what ifs of how services will be used, how they will expand and grow, which I support, but I want to make sure that the patient's interests are taken into consideration around cost. And the best way to do that in a bill like this, from my perspective, is to simply let them know that when a new service, which is an audio service, is being delivered as a chargeable event, newly, in other words, it's not necessarily a new service, but it's now going to be a chargeable event, that the patient is notified of that. That's all I'm requesting here. And I think it's very reasonable. And I'm not thinking of services like, although I understand the services you discussed, Representative Tepler, will be offered through an audio mechanism. However, I'm not talking about those services. I'm talking about, for instance, a primary care office that you have an established relationship with, and you call either after hours or even during the day, and you talk to the nurse for maybe 2-3 minutes about something. This happens all the time. I've done it probably hundreds of times, as I have 2 children, and et cetera, et cetera. And in the future, the industry may determine a way that they can charge a certain amount for those services. And if that was the case, as a patient, I think that they have a right and a need to understand that before they engage in the service.
So
that's all I'm saying.
So the guardrails on what providers can charge for and can't charge for under our system are generally put in place by insurance companies, and the limitations on them are put in place by insurance companies or by main care. And so I guess my question, Representative Arford, is if we were to put in place that sort of notice provision that you're proposing, which I think is designed to be a restriction on providers that you want us to put in Chapter 22, then what's the consequence if a provider doesn't do it? Is the consequence that the insurance company gets out of having to pay for the service? Is the consequence, like, what's the consequence? Is the consequence that the licensing board should be alerted and it's a licensing violation, right? I think when we put additional notices and like forms that folks have to sign, particularly when we're talking about doing it without technology, in a distance format, because we're here talking about a telehealth bill, we're putting another hurdle and barrier in access to care. And so that's my resistance to making the simple change that you're suggesting, is I don't know what the consequences are for violating it. And it feels to me like a barrier between the provider and the patient, imposed in the possibility that some provider might someday down the road start charging for things that they've never charged for before. Commissioner Head has her hand up, and she might have an idea for how to get us out of this mix. So I'll bring in Commissioner Head, and we can hear if she has a suggestion. Good morning, Commissioner. Go ahead.
Good morning. Thanks for the opportunity. The committee has just touched on something that is really, really important. And I appreciate Representative Arford's thought, but our licensing boards have been counseled year after year not to engage in any cost, billing, reimbursement issue of any kind. And the reason for that is, as Senator Sanborn just stated, that is a restriction that is not part of a licensing board's role. I do understand that the committee can go forward with any amendment that it sees as being helpful, but I did want to raise the issue that this is a red flag for us. And I understand the notification issue, but that can't come from a licensing board in terms of a rule, because we will now be, if that went forward, we would be talking about billing in licensing board meetings. And it's just not helpful. So there may be another way to do it that doesn't involve rules adopted by a licensing board. But that's why we did not adopt any of the language in 24A with respect to this issue. It has to be totally separate from any payment issue. I appreciate the time. Thanks.
Thank you, I keep calling you Representative Head. We have one of those too, but I meant Commissioner Head in this case. Is there further discussion on this point? We've talked about it quite a bit. I feel like there's one member of the committee who might feel differently than others, but I'm not sure where Representative Quint is now on it either. Representative Morris?
Yes, thank you, Madam Chair. No, I would be in agreement with your perspective on this personally, and I can't speak for anyone else on my side on that, but I personally would be in agreement. I don't think we need to get too involved in that. I think that, you know, if there does become an issue down the road, we can always address it then. But I think at this point, we want to ensure people have as broad an access to being able to access these services, because we are such a rural state, and wanting to make sure everybody has an ability to have some communication with a provider at some point. And I think that that's really what I think your bill is trying to address. So I would say that on that piece, I would be more in line with your way of thinking.
Thanks. Representative Matheson.
Yes, thank you, Madam Chair. Just a couple of things. I think that it comes down to personal responsibility with providers. I know that most of the integrated providers that I am in contact with have very transparent conversations with all of their patients about what is a billable time. And also we are regulated by our contractual agreements with insurance carriers as well as CPT codes. So there are very specific things that we can bill for, and a 5-minute consult at the end of the day that doesn't meet that criteria doesn't really fit into billing. So it wouldn't even be a conversation. But that being said, most of the providers I represent are very clear when a patient is going to be coming in to have an appointment with a provider, be it through telehealth, telephone, or in person. And at the point of sales where someone's scheduling something, that's an awkward time to say anything other than that, because the appointment could actually expand when you see the patient. So it's a complicated issue, but it's something that I think that is a personal responsibility for the provider and the patient to have that conversation, not to be mandated in law. I don't support that.
Representative Arford.
Yeah, I just wanted to say that I'm not quite sure how my comments that were simply stating that I believe that patients have a right to know if they will be charged for a new service could then be construed as in some way serving as a barrier to patients receiving services, because this is absolutely not my intention. It is simply, I think, a patient's right to understand when new services are offered, or they're offered in a different way, what the financial consequences will be for them. And it sounds like myself and Representative Quint may be the only ones in the committee that feel this way or think this way, and I accept that. However, I will ask the question of, there may be a much better way to let patients receive this information, and I'm all ears. If other people have other suggestions, I would love to hear it.
I think that's what Representative Matheson just talked about, that it was sort of a question of a provider's relationship with their patients and trust, and you know, that the professional ethics of a provider would be that they didn't want to undermine that trust. But I don't want to speak for Representative Matheson. That's just what I heard from what she said in her experience. She's nodding. So
Final
go
comment,
ahead, Representative Arford.
Final comment, Madam Chair, is this. this conversation would not happen most likely between the patient and their trusted provider. It would happen between themselves and the person who is scheduling the visit, which is a person who generally sits in the front office and does that and provides that service in most instances in an excellent manner. And I'm simply asking that what be added to the service they deliver is a notice to the patient if it's a telehealth service that has not before been delivered as a chargeable event, that they let the person scheduling it know that. And I invite everybody the next time they go see their provider, especially a primary care provider or a non-alternative care provider, to ask them what the cost of their service is, because every time I've asked, I've got the answer, I have no idea, because that's not something they discuss with their patients. So it's not something that normally would happen between a patient and their actual person delivering the service. It would happen at the time the service is scheduled. So that's all I need to say about that.
All right. I think we should move on. As I prefaced for the committee or previewed for the committee earlier, I think it makes sense to sort of have all of our corner caucus over lunch on this, and I hear a lot of consensus. It may not be entire, but I do hear a lot of consensus on both sides of the aisle with regard to this bill. So we can revisit it and determine whether whether there's unanimity or whether we need to have some change for some folks. So I guess at this point I would suggest that we table the bill if we've discussed all the parts of it that folks want to discuss on together on this meeting before lunch, and then we would pick it up this afternoon and revisit it potentially with a motion and with a vote. But I think I'll avoid even making a motion at the moment, and just I think we all know what the issues are and what's on the table. So I would, if there's no further hands going up, any other issues, all right, I'd entertain a motion to table.
So moved.
All right, thanks, Representative Connor. It looks like it's seconded by Representative Matheson, and we'll use the hands in the window sort of tabling. And Representative Tepler, we need your hand. Great, thank you. It's unanimous of those present. Representative Quint, do you want to, I guess you can't vote if we can't see your face, so sorry about that. Hopefully we'll be able to see your face this afternoon so that you can vote. Okay. So I want to get through a couple of more bills before we break for lunch. Having tabled the telehealth omnibus bill, the next bill that I would open a work session on is LD 863, which is the SIPACT bill. And I think we'll Commissioner Head, would you like to stay for us? Do you have comments on SIPAC?
Yes, please, if you don't mind.
I'd be happy to keep you there. And first we'll turn to Colleen and see if Colleen has any particular, I can't remember if you separated this out for the purpose of your analysis or it's just in the big chart.
It is in the big chart, but I have a page that I can share related
That'll
to
be great.
the bill, so I'll do that.
Thanks.
Yeah. So I'm gonna share this. Let's see where it is. I'm gonna go to the next page. I'm just gonna make it a little bigger. So it's this box at the bottom related to LD 863. As Senator Sanborn said, this is a bill that would authorize Maine to join the Psychology Interjurisdictional Compact. And this is an interstate compact designed to facilitate the practice of telepsychology and the temporary in-person face-to-face practice of psychology. Unlike the other compact that we're going to talk about a little later, which is sort of broadly would allow practice in other states through the interstate compact, the LD 863, the compact that is proposed for Maine to adopt is limited in to practice of psychology in compact states in 2 ways. One, it would permit a psychologist licensed in a compact state, if Maine joined, to provide telepsychology services in other compact states, subject to the scope of practice and licensing requirements of the state where the patient is receiving those services. So it does allow the practice of telepsychology if someone is granted the privilege through the compact. And then secondly, it would also permit a psychologist licensed in a compact state to provide temporary in-person services, for up to 30 days in another compact state. So those are the 2 primary elements of what LD 863 would provide. You did have some comments that were submitted in writing from the licensing board, and Commissioner Head may have further comments, but one of the issues that was raised was the extent to which this might impact the authority of a licensing board here in Maine. As a member of the compact, states agree to follow compact rules and requirements with regard to these two authorizations under the compact that I mentioned. And they also raised some issues related to the potential inconsistency between rules of the compact and what might be provided under existing state law. The other thing to mention about this particular compact is it has been adopted in enough states, so it has just become effective and licensed, each depending on how each compact, interstate compact, is designed and developed. It typically will require a number of states to enact and adopt the compact before the compact becomes operational. And this particular psychology compact has recently been triggered, if you will, by its adoption in, I think it was 7 states under this compact. So the compact is in the process of developing the rules and requirements for each of its member states. The last thing I would mention is LD 863 was presented as a concept draft. So the language of the compact was included as sort of the summary of the bill. And if the committee moves forward with the legislation, it will have to be drafted up as a bill and as an amendment to LD 863. And then same as I mentioned with regard to our discussion of the telehealth legislation, and I'll stop sharing. Under the current executive order, there are some telehealth services are authorized, and so the committee might want to think about the potential for some gaps, I guess, if you will, where someone can provide these services currently under executive order, and then if this is authorized or the executive order authorization goes away, there'll be some time frame under which there might be some differences in how a psychologist may practice telehealth services, particularly between when and if the state of emergency goes away and when and if this compact is adopted. And I'll stop there. I'm happy to answer any questions, and I know that the commissioner is here to answer some of your questions. I would also note that the committee did receive some additional information from the Maine Psychology Association in response to some of the questions that you raised at the public hearing, and that was distributed to you by email, and it has been uploaded to the electronic committee file.
Thank you, Colleen. So I'm going to start by asking if there are members of the committee who have questions for Colleen. All right, so seeing none, Commissioner Head, I think it's the sense of the committee that we're fairly interested in adopting compacts where they're available, not just because of the ability for out-of-state providers to be able to then provide services in Maine, but because it allows Maine-based providers to potentially expand their practice as well. Can you speak to, I guess my question is, did you have specific comments that you wanted to bring to the attention of the committee at this work session?
Yes, if the committee wouldn't mind. To me, and our position is neither for nor, so I'm not speaking against anything, but I do want to raise some timing issues. I don't see this as something urgent. We already have licensure endorsement for psychologists. We are also moving forward with 149, which will provide license by endorsement for many other health care providers that we have in OPOR. We don't really know anything more than we did on the day of the public hearing. I haven't looked at the Psych Association's new information, and I apologize for that. But I did want to raise some issues around the, number one, I don't think it's urgent right now. Number two, as you know, our mental health boards are under some stress right now, and we are working very hard to stay up to speed on all incoming applications. And the two limited term positions that this committee graciously offered and went to bat for us on are in progress to speed up our process even more. This is, I don't want to bring up the other compact issue, which I think is much more in its infancy than this one. Certainly there are states that have incorporated this into their business, and that's fine. I have no particular need to make any negative comment about it. But this does impact the staff that's trying at the same time to work on its processes for our main licenses, license applicants, and our out-of-state applicants. So the more pressure we find ourselves under, and we are trying to be as speedy as possible, any additional work will fall on the same people who are doing that work for us in response to the committee's concern. So I just put that out there because I think there are different ways of providing for telehealth. And I understand Senator Sanborn's comment that this will allow main providers to do the same in other states. I do think we still have questions that we will need to suss out ourselves about the way the compact is organized and operates. I am a bit concerned about our understanding of what the rules are right now with respect to a compact state, its licensees, and which law would apply when a main practitioner is permitted to practice in another state according to that state's rules. So I think if there is any conflict there, I think my staff would like to understand that before moving forward. But really, those were the things I wanted to raise. Staff resources is always an issue. We have taken on much more work this session with the same level of staff resources, and we are doing the absolute best we can. So this would be an extra workload to get this underway in Maine and do everything else that we're being assigned and have a responsibility for. So those are my comments. That's really all I wanted to say on SIPAC.
Thank you, Commissioner Head. Representative Tepler.
Thank you, Madam Chair, and thank you so much, Commissioner. I do think that there are a number of questions that you have raised that are answered by the recent letter from the American Psychological Association. So, you know, I do hope that you will get an opportunity to take a look at that very shortly. I also am wondering whether setting the date for joining the compact back a little bit would help with your staffing shortage issues and whether that's something that the committee might consider to meet the needs of the department.
I don't know if those are, I think that second piece about a timeline might be a question for Commissioner Head. And I wonder, Commissioner Head, if you could give us a sense of whether you are kind of gaining on it, I guess I would say, in terms of digging out from the problems that we heard about and that there was a letter written about in the dead of winter this winter. So maybe you could speak to the timeline there.
Yes, that I think an effective date sometime next year would be helpful. I would, I can certainly offer a date in the future, but on the other hand, I did want to assure the committee that as of yesterday, in terms of the counselor licensing program, the staff has been 50% more successful in issuing licenses and reviewing applications than when we first started talking about this in March. So yes, it's not just the counselor's board, it's also psychology, alcohol and drug, and social work. So there has been a full court press on those 4 programs. I do think that as time goes on and we integrate the 2 new positions, even more progress will be made. But I would like to suggest the committee might want to extend the effective date into toward the end of 2022, or sometime in the next in the second session.
Okay. Is there further discussion, Representative Tepler?
My only concern with pushing the PAC back is the gap that Ms. McCarthy-Reed was referring to, and how we address that gap for providers who have been providing services under the emergency order.
Or under emergency orders in other states. Commissioner Head, do you want to speak to that?
Yeah, no, I'm not sure I can give an answer to that, frankly. I know that you've looked at how to bridge that gap in the telehealth area already. I'm wondering if I could just perhaps take the lunch hour and look at that very carefully and come back this afternoon with some more information on that, if that would be acceptable.
Sure, that would be helpful. Before we table the bill to give that time to the commissioner, I just also wanted to draw the committee's attention and maybe the commissioner's attention as well to a letter that we received, I think after the hearing from the Department of Health and Human Services Office of Behavioral Health, which identified one particular way that SIPAC would really help them, which is that they have been under an increasing number of court orders for community-based defendants who live out of state at the time of the court order, and they have had a difficult time finding an examiner to work for the state forensics services who is licensed in the state where the defendant is located, and have had to at times require the defendant to drive back to Maine for the evaluation, and that this has been very difficult during COVID, and that some emergency rules have been helpful. The emergency rules of other states, I think, would be the case in this regard, but that's not it's not a permanent solution, and that
Right.
the compact would be a solution that would allow them to more readily identify providers who could provide that type of service on their behalf. So I just wanted to flag that as, because I think it highlights this need to not create a gap between the expiration of the temporary licenses, and maybe you could speak more to that when we come back after lunch.
Okay, certainly.
Okay, great. Is there any further conversation about this bill before we table it? All right, then I'll move to table LD 863. Is there a second? Seconded by Representative Tepler. All those in favor, please put your hands in the window. All right, so we have tabled that bill unanimously. So far, we are not doing as well as we have done in past Mongo work sessions, friends. So anyway, Commissioner Head, we thank you for joining us. I'm going to move you back into the attendee group because we're going to pick up some other bills that aren't in your purview. Thanks. Okay. Again, before we break for lunch, I want to put a couple more things on the table. And I'm going to take a little bit out of order from what I've previously announced. Rather than picking up 1390 right now, I want to pick up 1045 instead, so that we get that out on the table before lunch as well. So that if folks do want to have any possibility of maybe being interested in it, they have the opportunity to hear my thoughts. So I'll open a work session on LD 1045. This is Representative Brooks's bill on universal healthcare. And I think rather than having Colleen go through her analysis on this bill, I want to just kind of lay out an amendment that I'm proposing in a course of action for LD 1045. So my suggestion here is that we make that really we can't proceed with a state-based universal healthcare plan of any sort unless we can marshal all of the money that is currently being spent to provide healthcare to Mainers and channel it through that single payer system in the state. And until we can do that, we would end up double paying for services, and then it would be unaffordable. And that we're, as a state, not able to marshal all of the resources like Medicare, VA benefits, TRICARE, and Medicaid dollars, and channel those all along with employer contributions from large employers in particular, who right now might be self-insured under the ERISA program. We don't have authority as a state to marshal those resources. And the advanced premium tax credits, the cost share reductions, all the different ways that the federal government is contributing to the cost of Mainers healthcare, we don't have access to those dollars right now under federal law. So my amendment would make the formation of the Maine's Healthcare Board contingent on a change in federal law that would allow for us to marshal those resources. There have been bills introduced in the past, and there's a bill I think that will be introduced soon, again reintroduced, that would allow for a new kind of waiver. I think they call it a 1335 waiver rather than 1331 waiver or 32 waiver that we're familiar with. So it would be a 1335 waiver. It would allow a state that creates a single payer program that model that meets certain criteria for universal coverage to access and marshal all of the federal dollars that are being spent on healthcare in their state to go to help fund that plan. So it would be a redeployment of those federal resources through the state innovation waiver. And it would also include an exemption from ERISA to allow all of the workers and Mainers to be part of the plan rather than having large employers be carved out under federal law. So my suggestion is that we amend the bill to say, if the federal government adopts such a waiver process, then 60 days later, the state, within the next 60 days, the governor would need to appoint the board. and then it would follow just the board appointment language of Representative Brooks's bill. And then that board would be tasked with designing a plan that would meet the parameters of the federal waiver rules, and would have, you know, some period of months to come up with that plan. And then that plan would have to come back to the legislature as for an implementing vote. So until the federal government changes the rules, nothing happens. No board is appointed, no additional study commission, no more let's write a report. And unless the federal government changes the rules, we don't do anything. But if the federal government did change the law, and this type of bill that allows for state innovation models to try this out, in the event it did happen, then we're on the path to take advantage of it and to move forward with it automatically without an additional need to come back to the legislature to form the board. But then it would come back to the legislature to actually get implemented. So that's my suggestion for how to proceed. I would also suggest a joint resolution encouraging Congress to adopt such a bill or to pass such a bill. And so those would be two different votes. We have put joint resolutions together out of this committee before, encouraging Congress, for example, to pass a bill allowing for importation of drugs from Canada, personal importation of drugs from Canada. And that passed, I think, with unanimous support in the legislature. So there's a precedent for us asking our federal delegation to do something by joint resolution. So that would be my plan. We would pass this amended contingent version of 1045, and there would also be a joint resolution. I have no idea if there's any interest in that from my Republican friends on the committee. I'm guessing there may not be, but I wanted to throw it out before lunch so that folks could have the chance to talk about it if they wanted to. And we could certainly talk about it here now as well. I'd love to hear from anybody who wants to make a comment about that proposed amendment. Representative Morris, go ahead.
Thank you, Madam Chair. I'll go. No, I we're really not interested in anything along those lines. I think the concern is binding a future legislature to something, and I'm not really interested in passing a bill on a what if basis. I obviously, knowing what was in the original bill was something that I couldn't support. I think to pass something else or a resolution, there's really no interest on our part, and or at least on my part, and I would guess my fellow colleagues' part, on the amendment either.
Understood. It's worth a try. Representative Tepler, go ahead.
Thank you, Madam Chair. And I have to say, I'm strongly in support of this amendment. I think we all know that the current system is thoroughly and completely broken, and that we need to find a way to replace it. And I think that allowing states to experiment with this, if the federal government does in fact allow us to do so, is a great way to find out how a single payer system might work. Thank you.
Representative Arford.
Yeah, thank you, Madam Chair. I just want to take a minute to thank Representative Brooks for the bill and thank our Senate Chair for this excellent solution to not having the wherewithal to fund the bill at this point, but looking to a mechanism that will be a game changer in being able to fund it. And that once that bill passes, that we would be able to then bring the bill up and forward and actually pass it. And we're allowing for a committee, the advisory group that is outlined in the bill, to at that point in time determine what will happen next. By the way, they have to report to our committee and to the entire legislature with whatever plan they come forward with, as it's stated in the bill currently. And for those of you who may want to do a little bit more research on this, the name of the federal bill is the State-Based Universal Health Care Act. And it is being introduced by Congressman Ro Hanna. So if anybody wants to look that up and learn more about it while we're on break, I suggest you do it.
Thanks, Representative Arford. Representative Brooks.
I also appreciate going in the direction of providing healthcare, obviously. And I believe this would be a move forward in communicating that need. And we do have a system that is not working for a lot of people. So many people lost their employment and their employer-related healthcare coverage during this pandemic. And before the pandemic, there were also a lot of people that could not afford to see a doctor, whether they could be underinsured or uninsured. But then with high deductible plans, it's really difficult for people to make that choice between healthcare, food, shelter, and to have a significant part of our population not have accessible healthcare until very late on in their disease. We just need to, acknowledge that it's a system that needs to be fixed, to be helped along the way. And I know that there are representatives talking behind me that may suggest alterations in the board as outlined in the bill.
Representative Matheson.
Yes, thank you, Madam Chair. Just wanted to say that this is probably the one bill that I've heard the most about, other than maybe one other bill that I've been involved in so far in this legislature. I've heard from no less than 65 constituents at all ages and all issues. And I don't think that we can ignore the stories that I've heard, and I would support this amendment at this point in time because I do think we need to make some changes. So I appreciate the amendment.
Thank you, Representative Matheson. Are there any additional comments on this bill? All right, Representative Evans, go ahead.
Thank you, Madam Chair. I would have to agree. We are at a point where something needs to change significantly. I see nothing wrong with the committee lobbying our federal legislators to get some fire into allowing more innovation at the state level. So it's not going to hurt us by doing that. And I see no reason why we shouldn't. Thank you.
Sorry about that. Had a rogue puppy. Thank you, Representative Evans. Representative Brooks, is that a new hand? Go ahead.
Yes, and I would want to clarify the board composition and integrate a suggestion. So there would be 5 patient members on the board, and they would be maybe I should make a motion or allow different discussion, but they just there would be 5 patient members with their primary interest being for a more reasonable situation, 5 employers, 7 provider that includes 3 physicians with at least 1 who must be a primary care physician, 1 registered nurse, 1 mental health provider, 1 dentist, 1 healthcare facility director, and one of the providers I would recommend having it as integrative medicine specialist.
I think that makes 8 providers instead of 7 though. So I'm not sure exactly how we'll wordsmith that, but we can work on that with Colleen. Okay. Are there any additional questions or comments? Representative Morris, I'll give you guys the option of tabling this, but it sounds like you're not that interested in that. So if that's not all that interesting, we might just proceed to a vote.
We're not interested in this
Okay.
in any form. So you can proceed to a vote.
No problem. We'll proceed to a vote. Then Representative Brooks, I'm going to lower your hands. Representative Tepler, go ahead.
Thank you, Madam Chair. Sorry, my box moved around for a second and I wasn't sure where I was. But I would like to make a motion ought to pass as amended by the amendment that Senator Sanborn has outlined.
And Colleen, I don't know if we need a separate amendment or like a separate vote on preparing a joint resolution. I know those are separate. They're separate items.
I don't think you need a separate vote. I mean, they will not be able to be introduced by the committee. So they would have to be introduced by one of the chairs. But if the committee can take a straw vote in support of that, then I can bring the language back and for review, which is what we've done in the past. And then one of the chairs will introduce it on behalf of the committee for introduction to the legislature. So
should I include that in my motion?
No, I think it'll be a separate straw vote because the motion will just be on the report, the divided report.
That makes sense.
Okay, so Representative Tepler has made a motion. Is there a second? Representative Matheson, I saw first, so we'll do that. Representative Arford, do you want to speak to the motion?
Yeah, I want to thank Representative Tepler. Thank you for the motion. And I just wanted to state that in the amendment, I would like to see some brief wording that defines what the patient participant will be in the group that we will be picking up this bill once the federal law is passed. And we can, I'm assuming that language can be worked out in the amendment. I just wanted to bring the committee's attention to what I see as a need for that.
Yeah, and I think what you had in mind, Representative Arford, is sort of like what do we call it? Conflict of interest provision, right? So that the patient isn't also someone who's like president of a hospital or something like that, that the folks who represent patients aren't also representing drug companies or something like along those lines. Is that kind of what you had in mind?
And or who would qualify to serve in one of the other positions.
Right. Yep. Great. Representative Connor, go ahead.
Thank you, Madam Chair. I couldn't let the good representative from North Turner speak for all of us without stepping up. So I agree that our system is broken. I fundamentally disagree with the approach that we're taking to fix it. But I do want to go on record as stating that we do need to do something. I just don't think that this method is the correct method. So I just wanted to state that, and I appreciate you allowing me to.
Of course. All right. Thank you for weighing in. Seeing no other hands up, it appears that the committee is ready for the vote on the motion. So this is an ought to pass as amended motion on LD 1045, and our new stand-in clerk will call the roll. Go ahead.
Okay, I have a list order that was given to me. I hope it's the correct one. All right. Representative Quint is technically absent.
Yep.
Representative Connor.
No.
Representative Blyer.
No.
Representative Morris.
No.
Representative Matheson.
Yes.
Representative Evans.
Yes.
Representative Arford.
Yes.
Representative Melarano.
Yes.
Representative Brooks.
Yes.
Senator Stewart. Absent. Senator Brenner is absent. Representative Tepler,
Yes.
Senator Sanborn,
Yes.
so 7 yes, 3 no, and 3 absent. Is there a minority report?
Ought not to pass.
Thank you.
Great. So then the next action of the committee would be the straw vote on whether we should promulgate a joint resolution in support of the federal government passing a provision for such a waiver. So I would just, I guess, ask those, it's just a straw vote rather than the report of a committee, so we can do it in a more informal way. So I'd say those who are in favor of such a joint resolution being prepared by the chairs, if you would raise your hands in the window box. All right, so it's 1, 2, 3, 4, 5, 6, 7 of the members present, with Senator Brenner absent. And those opposed to such a resolution, raise your hand in the window box. We've got 3 in opposition, with Representative Quint and Senator Stewart absent. All right, I think that concludes our work on LD 1045. It is not quite 12:30, which is kind of where I was aiming for. And we have Megan Garrett Reed still with us at this moment. So I'm going to turn to LD 1390 and open a work session on LD 1390, which is Representative Evans' bill. And I think Colleen, I would quickly have you go over your analysis of the bill.
Sure. Okay. So this is LD 1390. As Senator Sanborn said, this is a bill that would establish a program for easy enrollment in marketplace or main care coverage. It would establish a process to identify individuals and families who are uninsured but potentially eligible for those benefits by using the state income tax filing system. It would require the Bureau of Revenue Services to add checkoff boxes to the state income tax form that would allow someone filing their income taxes to identify that they are uninsured, and then the language of the legislation would authorize the Bureau to share that information with the marketplace. The marketplace would then determine potential eligibility and follow up with that individual filing the return. The language would also provide for a special enrollment period for those uninsured individuals, and would require the development of outreach materials and educational materials in consultation with the Superintendent of Insurance, the Marketplace, and the Department of Health and Human Services. The language also would create an advisory group to assist with improving the effectiveness of the program. Just really quickly, the ability of a state to establish such a program through a checkoff box on income tax returns is really reliant on a state having a state-based marketplace, and legislative authorization, I think, as everyone is aware, to establish state-based marketplace in Maine was included in legislation enacted last session. The implementation of the state-based marketplace is plans for that are ongoing, and it is expected for the 2022 plan year with enrollment beginning in November of 2021. There are 2 states at least that have developed similar programs, and these bill provisions are modeled after those programs in Maryland and Colorado. There were some suggestions for further amendments to think about maybe adding similar checkoff boxes or information on other types of forms, such as unemployment applications, and also perhaps to include information for consumers about where they could access inpatient assistance. As Senator Sanborn said, Ms. Garrett Reed from the Department of Health and Human Services, who is the acting director of the state-based marketplace, is here, and she can respond to some of your questions, but they did submit written testimony expressing some concerns about the timing to implement the provisions while the transition to a state-based marketplace is ongoing. So the committee may want to think about perhaps allowing some additional time to develop the program or delaying implementation. While we don't yet have any fiscal information, the written testimony that DHHS submitted did estimate the potential costs as between $300,000 and $500,000 for necessary technology changes, particularly. Although I don't think we have any specific information, perhaps as well, if there would be any additional costs to main revenue services to add this information to tax forms. And I'm happy to answer any questions. And as I mentioned, I believe Ms. Garrett-Reed is here and could be brought into the work session to answer questions as well. She is.
Are there questions for Colleen before we turn to Ms. Garrett-Reed? All right, seeing none, I am going to bring her in. Good afternoon, Ms. Garrett-Reed. Can you hear us? There you are. Nice to see you. We haven't seen much of each other this Zoom session. So I guess I'd like to start. I appreciated what you said in your letter, but I'd like to start with a bit of an update on the implementation of the state-based marketplace. Could you give us a little sort of status report of where we are and where we're headed and whether we're going to get there in time for November?
Yes, I'd be happy to do that. Thank you for having me here today. We are still moving at full speed in the direction of implementing the marketplace in time for the open enrollment period beginning on November 1 for plan coverage for 2022. I believe the last time that I came before the committee to provide an update, we let you know we're working with our technology vendor, are on track there in terms of the build of the platform itself, continue to engage with CMS on their oversight of that process, which is definitely a close oversight process. One thing I did want to mention is I think I had raised sort of this timeline in that presentation, but we do have a touch point with CMS in August for what's known as conditional approval of the transition to become a state-based marketplace. It is important up until that point that we be clear that this is a planned transition, and we don't have that formal approval until they convey it to us at that point. So that is one important sort of gatepost that we're working towards. I think the one other update I wanted to give is I know when I last spoke to the committee, we had also mentioned we were working on procurement of a call center vendor. We did make an award for that scope of services to Maximus and are working on a contract with them at this moment. So a significant development there, but in particular, just in the context of this bill and others that the committee is considering, I did want to make sure to be clear about that CMS approval timeline that we're working towards.
Okay. So I guess my question, and I think I speak for other members of the committee as well, is that I know back when we talked about the state-based marketplace, this Maryland model and now adopted in Colorado as well, of having an open enrollment period that coincides with when folks get their tax refund and when they could have targeted outreach based on the previous year's income to get them enrolled in the marketplace. Was definitely something we talked about when we were considering the state-based marketplace, and even before that, when we had our task force earlier on making sure more Mainers would get health coverage. It seems like a very powerful way to do it. So I guess I'm asking about the delay or the timeline that we would need to give you in order to allow for us to get to that functionality. And I'm wondering whether delaying it so that it is effective for tax year 2022, which means taxes that are actually filed starting in February of 2023, is a timeline that we can adopt. I understand there's a funding piece to it, and I fully appreciate that. But I guess I'm just trying to make it so that we're on the path to this powerful enrollment tool being available to Mainers, you know, in the soonest tax season we can get there. So throwing out that 1 year delay and wondering if I could get some feedback from you on that.
Sure. Yeah. And I should start by saying that I think, you know, we at the Marketplace are very interested, I think, as you all know, in increasing enrollment in Marketplace plans. I think being able to provide targeted, more intensive outreach to people that we know could use health coverage certainly is a powerful tool and something that we're interested in to complement broad awareness and advertising efforts that we have underway. I do think a concern that we had raised and do continue to have is the parallel timeline with the full Marketplace transition and just our desire to stay really focused on making sure that we have a Marketplace that operates well this fall, that there's a smooth transition for consumers. And so I do think that, you know, a delay or more flexibility on timeline would be helpful there. I did want to mention that I think the Marketplace, you know, reserves the right to set policies itself. So I think, you know, in terms of a question about whether it would be necessary to have legislative direction to do that, you know, that is something that I think we would at the Marketplace would have the authority to change in future years. If we saw a benefit to offering a SEP around tax time, I think the piece about data transmission, obviously, you know, the checkbox involved in this legislation is a little different from that, but did just want to call that out. The only other thing I'd say is I think given that this program and any program similar to it, you know, I know there was some discussion of doing something similar with unemployment insurance applications, for example, will have a cost associated with them from a technology and operations standpoint. So I would just also raise that I think we would, you know, just be considering flexibility to decide on which programs sort of provide the most benefit to consumers once we're up and operating and can dive into our own data and understand that better as well, you know, just to have the ability to pick and choose or set a strategy based on the information that we have coming in as a Marketplace. But I do think, you know, in terms of timeline, it would help with some of that concern to have a little bit more lead time so that we wouldn't be needing to do this development work alongside the full platform development work, if that makes sense.
Right. You'll have gone through an open enrollment process before you would need to start the process, you know, to get to a February 1st, 2023 implementation, for example.
Exactly.
Okay. And with regard, I mean, I think that a bill would be necessary in order to implement any sort of easy enrollment. Right, you could have a special enrollment period, but in order to have an easy enrollment, which is where the income data gets transferred so that forms are already filled out and the Marketplace kind of already knows that you can get $10 silver plan or whatever, that would require legislative authority. Is that your understanding?
Yes, I think that checkbox component on the tax forms and those changes perhaps would. Just one other clarification, if I could just mention it, because it was something that I heard some discussion of, I think, during the public hearing on this bill. I did just want to make sure that it was clear that we at the Marketplace wouldn't be able to make a determination of someone's eligibility using that incoming data. There are some data points that we have to collect from the consumer that don't sort of match against what they would be, including in a tax filing. So, for example, attestation of their immigration status, and also some differences in how we calculate eligibility based on income. We have to calculate it based on projected income for the coming year, as opposed to prior year income. So that was just one small clarification. You know, I think we could use the data that we had to, for example, pre-populate some fields in an application to provide outreach to consumers that would be more customized to say, if your income's the same, you could likely qualify for a plan along the lines that, you know, and provide some sense of cost, which, you know, could be helpful, but we would need them to come in and finish completing an application and submit it with us in order to actually get them enrolled.
Mm-hmm. Okay, but certainly you could say, you know, based on last year's income, you know, could be eligible for, you may be eligible for a $10 a month bronze plan or a $10 a month silver plan.
Yeah.
Okay. Thank you. Are there any additional questions for Ms. Garrett-Reed? All right, I'm going to send you back into the attendee role, and we thank you for joining us today. And I appreciate your hanging out a little bit past noon so that we could get to this bill. So thanks for joining us.
Thank you.
Okay. So committee comments, discussion. Representative Melrano.
Thank you, Madam Chair. So I think it should be part of our mission to get as many people covered as possible. Being uncovered by any kind of health coverage or having an being underinsured can ruin people's lives. And we need to work towards, will be such a great tool to get people enrolled in health coverage that don't know maybe that they do qualify for substantial subsidies on the marketplace. But I understand the point that the department brought forward, that they do need a sort of an extra year so that they can assure the smooth transition into the state-based marketplace for this first year round. So I would support pushing it back a year.
Thank you. Representative Tupler.
Thank you, Madam Chair. I too would support pushing it back a year. However, I want to add that I really think it's important that the marketplace provides this opportunity for easy enrollment. I think that that using the tool of people's tax returns or their unemployment filings is a really important way to reach people who might not even be thinking about insurance, like young people in particular, who will expand our pool of people eligible for insurance. And I just think that we need to find a way to make this work. Even if it involves, rather than a final determination, a preliminary determination of eligibility for a subsidy, that seems to me like a very good place to go.
Representative Arford.
I just think this is an excellent bill. I want to thank all the people that have been involved in bringing this to us. And I think simply the act of having this on the income tax return, allowing people to check off the box if they'd like, and knowing that there's someone that cares and that's going to be getting back to them and assisting them in finding some sort of affordable insurance, simply that message that we're giving to the people of this state is a very powerful one. So again, I want to thank those of you who have brought this to us.
Thanks, Representative Arford. Representative Bleier.
Thank you, Madam Chair. I'm also in favor of this bill. I think it is a great concept. I would be okay with extending out a year for the department's request. And thank you to Representative Evans for bringing it forward. So I will be supporting this bill.
Thank you, Representative Bleier. Are there any additional comments?
Yes.
All right. Representative Evans, did you want to make a comment? Go ahead.
Thank you, Madam Chair. I thought about the extension of time, and I would not be adverse to that. My main goal was to have this asset available for the state-based program to be incorporated during the development process. So the public announcements regarding the state-based program is the start date has been announced as 1 November. So pushing it back, the enrollment for tax year 2022, it allows for the forms to be on the tax, the state tax form. So I'm not opposed to that at all. I would there was one thing that did come up during the public hearing, and I think would be important, and Colleen, you may have to help me, because I would like to just add, and it may be under information sharing, the language that the patient would be notified by their choice of messaging. And that could be either email, phone, or a letter. So that allows for, some people may not have email, others would prefer to be notified by phone, or some people may be more inclined to respond to a letter. As I know if I get a phone call, a lot of times I don't recognize the number, I'll ignore it. But the point is to be able to meet the patients where they are to get the people enrolled however way we can. So we can just add that in. Otherwise, I'm fine with what everybody's said. So.
Yeah, Colleen, I think that there's a provision in there already that says it has to be by email if an email address is provided, but it may be what we should suggest is that it even, the check box is then followed by what's your preferred method for us to reach you.
Right.
And then,
I think that's right. Yeah. Because right now it requires both a mailed notice and if they also included an email address, an email notice. And so I think we can clarify that they are allowed, or as part of the checkoff, identify their method of communication and clarify that other notice provision. Sure. Yep.
Yep. I think that works. I think it's fairly smooth. And we've seen those types of preferred communication practice in other contexts. Great. Sure. Okay, Representative Evans, would you like to make a motion?
I would make a motion, Madam Chair, ought to pass as amended.
Great. Is there a second? Representative Tepler has seconded the bill. And is the committee ready for the vote? All right. So Sabrina, we're ready for you. Go ahead.
Okay. Representative Quint, absent. Representative Connor.
Yes.
Representative Blyer.
Yes.
Representative Morris.
Yes.
Representative Matheson.
Yes.
Representative Evans.
Yes.
Representative Arford.
Yes.
Representative Malarongo.
Yes.
Representative Brooks.
Yes.
Senator Stewart, absent. Senator Brenner, absent. Representative Tepler.
Yes.
Senator Sanborn.
Yes.
10 yes, 3 absent.
Great. Thank you so much. So it is now 12:39, and although Commissioner Head is ready to talk to us about SIPAC, I think it makes sense for us to take a break now. We'll pick the tabled bills up right after the break and hopefully be able to make some forward progress on them at that point. And then we'll move on to the rest of the list we have in front of us, which I actually think is going to go much more quickly than our morning has gone. Just as a preview, I actually still think we're pretty much on track, except for the part where we haven't voted the telehealth bills yet, but hopefully we'll get there pretty quickly after lunch. So I'm gonna, knowing that everybody needs to get together in caucus, we will take an hour lunch break until 1:40, and then we'll reconvene and like I said, pick up the tabled bills first and then go from there. All right. Have a wonderful lunch, everybody. It's beautiful outside. If you can go outside, do that too. All right.
Killer.
Okay, it is 1:40. We'll see who's around. Only see 5 members of the committee, so if there's others who are with us, you could turn your camera on and let me know you're here. That'd be great. Okay, well, we still only have 6 committee members. I don't want to do work sessions with only 6, even if we could, which we could, but I don't like doing that. So I will continue to wait. I have shot a text message out to our folks. Hopefully they'll be jumping on soon. Just for any attendees who might not have been with us first thing this morning, our plan is to pick up the SIPAC bill and the telehealth bills off the table shortly when we start up our work again, and then we will be proceeding with LD4 followed by LD31, 1646, 1660, 1629, 1622, 1268, 738, 1311, and 1661, roughly in that order. So that is the plan. All right, I still only see 7 faces. It's too nice out. Everybody had a long lunch. All right, there's Representative Arford's back. All right, we're starting to get more toward the majority of the folks who were at least with us before lunch, so that's great. So I think we'll get started. I think the first thing I'd like to do is take the SIPAC bill up off the table. That is 863, and we'll invite Commissioner Head, who I didn't check, but she is there, great. We'll invite, oh, I'm not a host anymore, so someone else will have to pull Commissioner Head back into the meeting and then maybe make me a co-host so I can help.
I'm trying and I'm getting a failure error, so maybe Sabrina can try to promote her. Unless there's more than one.
She's
hand
there
held.
now. She's
Oh,
there
okay,
now.
good. There we go. Great.
Great. Commissioner Head, can you hear us? There she is.
Yeah, I'm sorry about that.
No problem. So we asked you a question before we sent you away before our lunch break, and I understand that you have some feedback for us.
Yes. My understanding of your question, Senator, was what would be the plan if the temporary licenses were terminated because the pandemic was now extinguished? What would we do about the gap? And I guess what my answer would be, there may be more than one answer, but my answer is if any applicant with an out-of-state license applies to Maine today, that license with a valid record in another state, the application would be reviewed quickly and would be issued within 2 weeks. That's where we are with the psych applicants right now. That is obviously not the answer for people who are interested in having the compact in place. So I've talked to my staff, and although we still have concerns about certain aspects of the compact and a statement by the commission in its in the material that it has provided, that the compact rules would supersede any rules that the boards in a state have. I think we can negotiate or find our way through working with the committee staff on those issues. I'm sure that's what other states have done. And I don't think, in retrospect, I don't think that there's anything to be gained by changing the effective date of the legislation itself. There's still going to be a delay, obviously, but we can use that time to get acquainted with the commission staff, the rules, and we can identify those issues that we would like to have more discussion on. So I also have statutory authority as commissioner in the area of investigatory records, which under the compact would need to be forwarded to the commission, not for processing by the commission, but so that another state would have a record that we think is important for another state to have. Currently, that would violate our confidentiality rules on investigatory files. However, I could exercise my authority as commissioner in certain circumstances to make sure the release of those documents occurred. So I think overall, I'd like to invite the committee to move forward. We will do whatever we have to do to comply with the rules of the compact. And there is a set schedule for that. As soon as the legislation is effective in, I don't know, mid-September 21, within 15 days, our participation will be acknowledged by the commission, and within 90 days, we will need to identify a representative from Maine to work with the commission. So we're happy to do that.
Okay, thank you very much. I really appreciate your support or ability to support. I think what the committee was leaning toward and your thoughtful work with your staff on how we should best proceed. So I really appreciate you taking the time to do that. Are there any questions for Commissioner Head or any additional comments from the committee?
Just
Representative Arford, go ahead.
Thank you, Madam Chair, and thank you, Commissioner Head, for being with us this afternoon. this may be in the testimony, and if it is, I apologize for not having the time to go back and review all the testimony, but could you just provide a very, a usual example of the compact, what might be in the compact for a rule that the state of Maine would not have for a rule? You said that we would be obliged to abide by their rules, and we might not, how you would work that. I'm just curious as to what the difference might be.
I think the best example that I could give is in the area of, as I said, there's a statement in the compact material that says that compact rules supersede a state statute or rules. And if we don't know exactly what that means, it's hard to know how that would affect Maine in general. For example, Title 32 is the statute, the title of Maine law that contains all of the professional licensing statutes. That's specifically for a profession. However, in Title 10, which contains the enabling statute for the department, it also contains the process for handling complaints for OPOR boards. So if there is any, so my question is, are you saying that our Title 32 might be affected, or are you saying that the Title 10 structure would be affected? And only by talking to the staff of the commission would we ever know that. So I think over time, we would get to the point of understanding what those statements that are in the bylaws and the guidelines, then we will know what those statements mean. I think it's a little hard from standing outside the compact to know exactly what the answers are. But I think we are willing to take the step of acknowledging the compact, and we will work with the commission staff and other states to make sure it works for Maine.
And just final thought, is there an exit opportunity for, if your department, for whatever reason in the future, decided this was no longer in the state's best interest? Is this something that is renewed every certain number of years, or?
Actually, there is a way we can remove ourselves from the compact at any time. There may be some ramifications in terms of the annual fee paid to the compact for operations, but I am not aware of anything that would make a state stay in the compact if for some reason there was a good reason why we couldn't continue. So yes, we are signing a contract. I don't have a copy of the contract, but I am sure we could work out any situation with commission staff. I think there are some states that have removed themselves from other compacts. I think it just depends on the individual compact documents.
Thank you.
Are there any other comments? Representative Evans, go ahead.
Thank you, Commissioner. So the compact, what oversight, who oversees or accredits the compact?
The Compact Commission oversees the compact, and it is the agreement of all member states that gives the commission that authority. So there is no overarching agency that oversees these compacts. It is really the agreement of states to work together that keeps the program together.
So the inter compact reporting is limited to compact states, or does it extend beyond the state?
it
Say
would
if
be
you have
limited. It would be
Well-
limited to compact states. Yes.
Thank you.
Okay. Great. I don't see any other hands up. Is there any further discussion on 863? All right. In the interest of time, I'm going to move ought to pass as, is it amended, Colleen, or is it amended?
Definitely amended. It hasn't been drafted yet. It's concept draft. So.
Okay. So ought to pass as amended. And is there a second? Representative Melrano seconds the bill. Is there any further discussion about the motion? All right, Representative Tepler, go ahead.
Thank you, Madam Chair. And I do want to say that we actually have language, even though it was a concept draft, that Mr. Howe drafted language, and that this is not like a complete unknown whole. We have the language, and Colleen has to adapt it more thoroughly to Maine law, but we definitely have language.
Yeah. The summary of the bill includes the model compact legislation that was drafted by the commission for adoption by the states. But Representative Tepler's right, it needs to be conformed to Maine's drafting standards. So I'll have to take that language and put it into Title 32.
Great. All right. So seeing no further discussion, Sabrina will call the roll.
Okay. Representative Quint, absent. Representative Connor.
Yes.
Representative Blyer.
Yes.
Representative Morris.
Yes.
Representative Matheson. Absent. Representative Evans. You were muted.
Yes.
Perfect. Representative Arford.
Yes.
Representative Melrano.
Yes.
Representative Brooks. Absent. Senator Stewart. Absent. Senator Brenner. Absent. Representative Tepler.
Yes.
Senator Sanborn.
Yes.
8 yes, 5 absent.
Great. Okay. So the next thing that we're going to do as a committee is to pick up the telehealth bills. But the plan is that we'll leave 791 on the table today. Some members of the committee have requested additional time to be able to review the draft that was circulated during our meeting today. So that's fair. But I would like to pick up all the other bills because I think the committee is generally moving in the direction of using 791 to take the place of all of the other bills that we have on the table at the moment. And so I would like to just dispose of the other bills, in part because it'll make me feel better that we voted some bills at least today, rather than leaving like 15 bills sitting on the table after today's work session. So does that sound like a plan for everybody? Everybody good with that? Okay. So the first bill that we will pick up is 1681. The full text of 1681 will be incorporated into 791. It's anticipated. So I would make a motion ought not to pass. Is there a second? Seconded by Representative Blyer. Is there any further discussion? Seeing none, the clerk will call the roll.
Representative Quint. Absent. Representative Connor.
Yes.
Representative Blyer.
Yes.
Representative Morris.
Yes.
Representative Matheson. Absent. Representative Evans,
Yes.
Representative Arford,
Yes.
Representative Melrano,
Yes.
Representative Brooks, absent. Senator Stewart, absent. Senator Brenner, absent. Representative Tepler.
Yes. Oh, I'm sorry. Yes to.
Yes is
not
the right
pass.
answer. Yes,
Yes,
you're
okay.
good.
Senator Sanborn.
Yes. All right, we're gonna get a lot of these, so everybody get in a rhythm here, okay? The next one is LD 323. Again, some elements of LD 323 will likely be incorporated in 791. I'll move ought not to pass. Is there a second? Representative Tepler has seconded. Is there any further discussion? Seeing none, the clerk will call the roll. I'll give you a minute, Sabrina, to catch up on the vote sheet.
All set. Representative
Okay.
Quint, absent. Representative Connor,
Yes.
Representative Blyer,
Yes.
Representative Morris,
Yes.
Representative Matheson, absent. Representative Evans,
Yes.
Representative Arford,
Yes.
Representative Melrano,
Yes.
Representative Brooks, absent. Senator Stewart, absent. Senator Brenner, absent. Representative Tepler,
Yes.
Senator Sanborn.
Yes.
8 yes, 5 absent.
All right, the next bill is LD 333. Again, there are parts of, at least one or two parts of LD 333 anticipated to be incorporated into 791. I would move ought not to pass. Is
Second.
there a second? Representative Connor has seconded, and the clerk will call the roll.
Representative Quint, absent. Representative Connor,
Yes.
Representative Blyer,
Yes.
Representative Morris,
Yes.
Representative Matheson, absent. Representative Evans,
Yes.
Representative Arford,
Yes.
Representative Melrano,
Yes.
Representative Brooks, absent. Senator Stewart, absent. Senator Brenner, absent. Representative Tepler,
Yes.
Senator Sanborn.
Yes.
8 yes, 5 absent.
The next bill is LD 649, and I would move ought not to pass. Is there a second? Representative Tepler has seconded, and the clerk will call the roll.
Representative Quint, absent. Representative Connor,
Yes.
Representative Blyer,
Yes.
Representative Morris,
Yes.
Representative Matheson, absent. Representative Evans,
Yes.
Representative Arford,
Yes.
Representative Melrano,
Yes.
Representative Brooks, absent. Senator Stewart, absent. Senator Brenner, absent. Representative Tepler.
Yes.
Senator Sanborn.
Yes.
8 yes, 5 absent.
Okay, the next bill is LD 849, and I would move ought not to pass. Is there a second? Representative Tepler seconds the motion, and the clerk will call the roll.
Representative Quint, absent. Representative Connor,
Yes.
Representative Blyer,
Yes.
Representative Morris,
Yes.
Representative Matheson. Oh, she just came in. Say right now, Representative Matheson, it's actually your turn to vote. We're on 849, ought not to pass. if you would like to.
I think I'm going to come back to me in a sec, please.
Okay. That's fine. Representative Evans.
Yes.
Representative Arford.
Yes.
Representative Melrano.
Yes.
Representative Brooks, absent. Senator Stewart, absent. Senator Brenner, absent. Representative Tepler.
Yes.
Senator Sanborn.
Yes.
So then it would just be Representative Matheson again.
Yes, thank you.
So 9 yes, 4 absent.
All right, the next bill is 1007, and I will move ought not to pass. Is there a second? Seconded by Representative Connor. Thank you. And the clerk will call the roll.
Representative Quint, absent. Representative Connor.
Yes.
Representative Blyer.
Yes.
Representative Morris.
Yes.
Representative Matheson.
Yes.
Representative Evans.
Yes.
Representative Arford.
Yes.
Representative Melrano.
Yes.
Representative Brooks, absent. Senator Stewart, absent. Senator Brenner, absent. Representative Tepler.
Yes.
Senator Sanborn.
Yes.
9 yes, 4 absent.
Okay, the next bill is LD 1194. I would move ought not to pass. Is there a second? Representative Matheson has seconded. Representative Matheson, you have your hand up. Is that just a second?
It was a second, but I also, yeah, I wanted to say that I could vote for the other bills that I missed too.
Oh yeah, we'll circle back to you, and I'll have Sabrina call you on all of those before we go off this topic. So I think we're on 1194, and it's been moved and seconded, and the clerk will call the roll.
Representative Quint, absent. Representative Connor.
Yes.
Representative Blyer.
Yes.
Representative Morris.
Yes.
Representative Matheson.
Yes.
Representative Evans.
Yes.
Representative Arford.
Yes.
Representative Melrano.
Yes.
Representative Brooks, absent. Senator Stewart, absent. Senator Brenner, absent. Representative Tepler.
Yes.
Senator Sanborn.
Yes.
9 yes, 4 absent.
And there's one left, which is 1361. I would move ought not to pass. Is there a second? Representative Evans has seconded it, and the clerk will call the roll.
Representative Quint, absent. Representative Connor.
Yes.
Representative Blyer.
Yes.
Representative Morris.
Yes.
Representative Matheson.
Yes.
Representative Evans.
Yes.
Representative Arford.
Yes.
Representative Melrano.
Yes.
Representative Brooks, absent. Senator Stewart, absent. Senator Brenner, absent. Representative Tepler.
Yes.
Senator Sanborn.
Yes.
9 yes, 4 absent.
All right, great. So like I said, but some folks weren't on yet, we are going to leave 791 on the table, and we anticipate circling back to that on Thursday. Just giving everybody a chance to actually read the amendment without the time pressure involved in doing it today. Okay, so the next bill on our list to pick up today is LD4, which we've had a prior work session on, but had another, actually I've had 2 prior work sessions now because we had a work session last week, which was really a little mini public hearing related to an amendment which I have proposed that would allow for compounding pharmacies, retail compounding pharmacies for veterinary medicine. So since the public hearing, we've heard from some folks from the veterinarian community, some additional folks who wanted to ensure that the rulemaking process that the Board of Pharmacy will engage in has input from the Board of Veterinary Medicine. And so I would like to just amend the amendment to require the Board of Pharmacy to collaborate with the Board of Veterinary Medicine on the drafting of the rules. Does that make sense, Colleen, in terms of how you can write it?
Sure. Yep.
Okay, great. And other than that, I don't think there were other concerns. Colleen, was there anything else in your analysis?
Well, I didn't do an analysis because, but two things I wanted to mention. One is a technical issue. One of the provisions sort of defines what compounding is, but as part of the definition, it also says that compounding can't happen until rules are promulgated. And so it's just a technical thing, but the revisor's office drafting standards are that sort of substantive provisions shouldn't really be included in a definition. So I would just move that to a different, to its own section or subsection to be consistent. And then because of that the language says that no compounding for veterinary office use is permitted until the rules are promulgated. There's no specific timeline in the statute, in the draft as presented, that for when the rules should be adopted. So I didn't know if the committee wanted to consider that or consider perhaps adding an emergency or setting a specific timeline for when these rules would be adopted.
Yeah, and Representative Tepler, go ahead.
Thank you, Madam Chair. And I just wanted to ask, well, how long does a rulemaking process under APA guidelines generally take?
Colleen, you're on mute.
I think it really varies under, the statute as to how quickly, but there are requirements for sort of the draft rule to be developed by the agency. And then there are specific requirements for providing that rule for public comment. And when there is there can be a hearing held. And then the board has to consider any written comments that are submitted under the APA and respond to those comments and then adopt the rule. And as part of that process as well, the rule is reviewed by the Attorney General's office in addition to sort of internally within the department. So, I think generally it's, I would say, a several month process, although there are some procedures within the APA for emergency rulemaking to happen. But as this legislation is drafted, it would provide the authority to the board and put the requirements in statute if it is enacted sometime in September, because it has a general effective date right now.
So I would suggest that we add an emergency clause. I think everybody's in favor of the bill. So I would suggest an emergency clause, but I wouldn't suggest a timeline for the rules. I think that there's some pretty strong constituencies, not just Covetrus, but actually the veterinarians who reached out to me also want to see this happen. And so I think that there's plenty of pressure that will be applied to make sure that the Board of Pharmacy proceeds, because there's both economic development and medical or veterinary, at least, reasons for proceeding with these rules. So I feel confident that the board will not forget about it or ignore our permission. So I would just suggest that we add the emergency clause. Representative Tepler. You're on mute.
Thanks, Madam Chair. No, now I'm not. I just wanted to move ought to pass as amended with the emergency clause, except Colleen is waving her finger, which indicates that we need to talk about something else.
No, I only would say that I don't think we formally reconsidered our earlier vote. So I think we need to do that first, and then you can make another motion, because we previously voted on LD4 to pass as amended. So I think we want to reconsider, revote, include that earlier amendment plus the amendments we're talking about, just to do all the process the right way.
Okay. So
is that a roll call? Is that a roll call vote?
I
for
think so, with the
reconsideration?
reconsideration. I think
Okay.
just to be fair and have it documented. But it
Okay.
was unanimous, so anyone is on the prevailing side and can make the motion to reconsider.
So
Representative Tepler.
having voted on the prevailing side, Madam Chair, I move that we reconsider our previous vote on LD4.
Okay, is there a second? Representative Connor seconds the motion. So this is a motion for reconsideration on LD4, and the clerk will call the roll.
Representative Quint. Absent. Representative Connor.
Yes.
Representative Blyer.
Yes.
Representative Morris.
Yes.
Representative Matheson.
Yes.
Representative Evans.
Yes.
Representative Arford.
Yes.
Representative Melrano.
Yes.
Representative Brooks. Absent. Senator Stewart.
Yes.
Senator Brenner. Absent. Representative Tepler.
Yes.
Senator Sanborn.
Yes.
10 yes, 3 absent.
Okay. And so now I need a motion on LD4. Representative Tepler, go ahead again.
I move ought to pass as amended by both the emergency clause and the committee amendment.
Second.
Seconded by Representative Connor. Is there any further discussion? All right, the clerk will call the roll.
Representative Quint. Absent. Representative Connor.
Yes.
Representative Blyer.
Yes.
Representative Morris.
Yes.
Representative Matheson.
Yes.
Representative Evans.
Yes.
Representative Arford.
Yes.
Representative Melrano.
Yes.
Representative Brooks. Absent. Senator Stewart.
Yes.
Senator Brenner. Absent. Representative Tepler.
Yes.
Senator Sanborn.
Yes.
10 yes, 3 absent.
Okay, great. The next two bills that we're going to pick up are the occupational therapy bills. Those are LD 31 and LD 1646. And Colleen, I'm going to have you do your presentation because we haven't worked these bills before.
Share this now. I did the analysis on both of these bills, although they're related, but not they're different. But LD 31 is a concept draft, and this is a bill like LD 863 that would adopt a compact related to occupational therapy licensure. Under the compact, as it's drafted, it would allow licensed occupational therapists and licensed occupational therapy assistants in states that belong to the compact to apply to the compact for the privileged practice in other compact states. LD 1646 also makes changes related to the laws licensing occupational therapy. And it does two things primarily. One, it repeals and replaces the current definition and description of what occupational therapy services are. And two, it establishes or reestablishes actually in statute requirements for continuing education for license renewals and continuing education for reinstated licenses. With regard to LD 31, we did get some testimony from the Board of Occupational Therapy Practice related to the model compact legislation. Unlike LD 863, which we just talked about, the model compact bill was only finalized in late 2020. And as it's written, this compact does not become effective until 10 states have enacted the compact legislation. LD 863, the SIPAC, is effective after 7 states enact it. At the end of March, Virginia was the first state to enact the compact, although in April, I think 1 or 2 more additional states have enacted the compact, and there are several other states that are considering adoption during this legislative session. Given that the compact commission itself hasn't really been activated yet, I think the board's testimony did raise some concerns about the potential impact on state authority of the compact, because the rules have yet to be developed. And as was noted earlier, the way the compact is drafted, it is a contract among the states, and there is language that to the extent that there is any conflict between an individual state's law and the compact as it's drafted, or any rules adopted pursuant to the compact, the language does say that the compact would supersede any state law to the extent of that conflict. The board also noted, as we talked about earlier too, that the member states as members of the Compact Commission are subject to an annual assessment to support the costs of the Compact Commission. There's also a potential administrative cost to the state to grant privileges under the compact for those occupational therapists and occupational therapist assistants in other states asking for a privileged practice in Maine. Although there is language in the compact that does permit each member state to charge a fee for granting the privilege. And then, as also we talked about earlier, we talked about 2 of the other pieces of legislation that are being considered by the IDEA committee that have been put forward to try to streamline and reduce barriers for licensing of out-of-state providers and make the movement between states and licensing of credentialed individuals easier. So LD 149, which we've talked about, would set up a process in statute to allow rules to be developed by the licensing boards administered by the department to grant licensure by endorsement to applicants who are licensed in other states, in foreign nations, or other entities. And then LD 374 also is a bill that's being considered by the IDEA committee that specifically relates to veterans or active duty members and their spouses who hold occupational or professional licenses or certifications that would allow them to obtain temporary licenses in Maine while completing their license requirements here. So those are 2 pieces of legislation that that were noted as part of the testimony. I wanted to make you aware of that language, and those are working through, have been supported by a majority of the IDEA committee, and those bills are working through the process. I don't know if you want to take them one by one. We could sort of stop if you want me to just continue and sort of note the issues related to LD 1646.
I think you can note the issues related to 1646, sure, and then we can discuss them.
Okay. And then with regard to LD 1646, there are 2 main components here. One is the proposed repeal and replacement of the definition of occupational therapy. The testimony is indicated that it's intended to be updated to be consistent with the model definition of the American Occupational Therapy Association. The licensing board's testimony did indicate that the board, as they see it, does adopt the model definition, but adds dry needling, which was not specifically added to the model definition. And they also noted some language in the bill related to wound care for your consideration. And then with regard to the continuing education requirements, this is a requirement of the compact that member states, if the state does move forward and become a member of the compact, that the state have continuing education requirements for occupational therapists. So LD 1646 would put in place a statutory requirement for 8 hours of continuing education. The board's testimony did note that there were previous requirements in statute for continuing education that were repealed in 2012 by board rule. And then the statutory requirement was repealed in the 129th legislature. I'd also note that there is existing authority for those licensing boards, which are within the Office of Professional and Occupational Regulation. There is general authority that for those boards to adopt continuing education requirements by rule. Although currently there is no board rule in place for continuing education. So the committee might consider whether the statutory provisions in the bill can be removed or replaced, perhaps with a directive to the board to adopt rules for continuing education requirements. And I would note too that the bill's provisions are really very detailed about what curricula and what sort of category of continuing education requirements are required, and those details may be better suited for rules rather than statute, and that's consistent with how continuing education is treated for other licensing boards. Really, a lot of the specifics about how many hours and what types of continuing education curricula qualifies are set forth in board rule. And then with regard to the fiscal information, we don't yet have any particular information about LD 31, but the preliminary statement from the board indicated that if LD 1646 moves forward, that any requirements to implement can be absorbed within their existing budgeted resources. I'd also note that you did get some additional information from the Association of Occupational Therapists, in part in response to some of the testimony, the written testimony you received from the licensing board, and that was emailed to you yesterday. And I do know that Commissioner Head and others from the department are here and can answer any questions that you might have about the specifics of this legislation.
Thanks, Colleen. So on these two bills, I guess on 1646, so these are both my bills. On 1646, I do want to propose a couple of amendments before we even kind of start talking about it, because I think there were some real issues with the drafting here. And it kind of came together at the last minute, as you can see by the very high LD number, even though it was a pre-cloture request. So the first thing I would say is that I really want this to stick to the model definition. And so I would ask for Colleen, to work directly with the board to sort of redline during language review. Hopefully just, it should stick with the model definition and not expand it beyond that. And then the purpose of section 3 and following of the bill really was just to add back in the continuing education requirements in order to be able to comply with the requirements of the compact. So I would request that we strike out all of that detailed language but make the adoption of rules not optional, but mandatory with regard to continuing education that is sufficient to meet the minimum requirements of the compact membership, which is sort of what the point of the bill was, I think. So that's the way I'd like to proceed with that bill. And then the other bill is the compact language. So that's pretty standardized model language that would need to be developed or into, main statutory format. But I think we're pretty close to there on that. So is there a discussion on the committee? Nobody has any discussion. Okay. Are there motions? Representative Matheson, go ahead.
I think I'm making the right motion, but I'll make a motion ought to pass as amended. Is that proper, or yes?
Yeah, we should specify on which bill. So there's two bills. The first one probably is 31.
31, yep. So
That's the compact.
Yep. So the first motion is to ought to pass for LD 31 as amended.
Okay. Is there a second? Representative Evans has seconded. And is there any further discussion on LD 31? All right. Seeing none, the clerk will call the roll.
Representative Quint, absent. Representative Connor,
Yes.
Representative Blyer,
Yes.
Representative Morris,
Yes.
Representative Matheson,
Yes.
Representative Evans,
Yes.
Representative Arford,
Yes.
Representative Malrano,
Yes.
Representative Brooks, absent. Senator Stewart,
Yes.
Senator Brenner, absent. Representative Tepler,
Yes.
Senator Sanborn,
Yes.
10 yes, 3 absent.
Great. And then the second bill will be LD 1646 as amended. Is there a motion? Representative Matheson again.
I'll make a motion to ought to pass 1646 as amended.
Great. Is there a second?
Second.
Seconded by Representative Connor. And is there any further discussion? Seeing none, the clerk will call the roll.
Representative Quint, absent. Representative Connor,
Yes.
Representative Blyer,
Yes.
Representative Morris,
Yes.
Representative Matheson,
Yes.
Representative Evans,
Yes.
Representative Arford,
Yes.
Representative Malrano,
Yes.
Representative Brooks, absent. Senator Stewart,
Yes.
Senator Brenner, absent. Representative Tepler,
Yes.
Senator Sanborn,
Yes.
10 yes, 3 absent.
Great. The next bill that we're going to pick up is LD 1660, which actually comes to us from the Board of Dental Licensure and relates to the licensing of dentists and hygienists who are trained in other countries. Colleen, do you have a bill analysis for us on that one?
I do. I can do it really quickly if you'd like.
Sure.
Sure. As Senator Sanborn mentioned, this is a bill from the Board of Dental Practice. As it's drafted, it would authorize or give discretion to the board to grant on a case-by-case basis licensure to otherwise qualified applicants for all their forms of licenses. So it would apply to dentists, limited dentists, dental hygienists, and other licensees who did not obtain either a doctoral degree in dentistry or a dental hygiene program from an accredited program. It would allow the board to consider educational equivalency in determining the educational qualifications. And then secondly, it would also give the board discretion on a case-by-case basis to grant licensure to otherwise qualified applicants who are licensed in good standing in the United States or a foreign nation. As it's drafted, the bill's an emergency, and so if it's enacted with 2/3 vote, it would take effect when enacted. And I think you did have some testimony from the Board of Dental Practice that there are some current applications pending that this could assist. The bill as it's drafted would essentially provide for a licensure by endorsement process and allow the board to consider both educational equivalency and then sort of the license in good standing from other United States or foreign nations. It's similar to the authority that would be provided as part of LD 149, which we've talked about, which would grant authority, the discretionary authority to provide licensure by endorsement to the licensing boards that are within the jurisdiction of the Office of Professional and Occupational Regulation. The Board of Dental Practice is sort of an affiliated board outside of the department. So the statutory language in LD 149 doesn't extend to them. So that's why you have LD 1660 before you. And under current law, there are statutory language that only allows the board, for instance, with regard to educational degrees, to only consider degrees from in another United States. And then also with regard to the licensure by endorsement provisions that are in statute, only allows the board to consider licenses from other states or from Canada. It doesn't allow the consideration of licensing from other countries. So LD 1660 will address that. And then the board has indicated that any additional costs of implementation can be absorbed within their existing budget.
Great. Is there discussion on the bill? All right, seeing none. Colleen, is this an ought to pass as amended because there's a fiscal note, even though it doesn't say much, or is it ought to pass?
It can be straight ought to pass because it's a minor sort of cost absorbed fiscal note. So you can, and there are no other amendments as I can see that are needed. So this can be a straight ought to pass.
Fun. We never get to do that.
Not very often.
So I would move ought to pass. Representative Connor, you can
Beat me to it, Madam Chair. I was going to make that motion. I'll second your motion.
You guys have gotten all quiet this afternoon, so I decided I would just take motion making into my own hands. But thank you for stepping up, Mr. Representative Connor. I'll call on you next time. All right, the clerk will call the roll.
Representative Quint. Absent. Representative Connor.
Yes.
Representative Blyer.
Yes.
Representative Morris.
Yes.
Representative Matheson.
Yes.
Representative Evans.
Yes.
Representative Arford.
Yes.
Representative Malrano.
Yes.
Representative Brooks. Absent. Senator Stewart.
Yes.
Senator Brenner. Absent. Representative Tepler.
Yes.
Senator Sanborn.
Yes.
10 yes, 3 absent.
Great. The next bill is LD 1629. And I think we have a board amendment. Colleen, why don't you walk us through whatever you think makes the most sense?
Sure, I'm happy to walk you through that. I didn't have it pulled up, so let me see if I can find it quickly. I can find it. I might mess this one up. Okay. So I'll pull up, let's see. I think I'll give you the analysis first really quickly, just to refresh your memory, and then I can pull up the proposed amendment. The bill this is LD 1629, an act regarding the qualifications for licensure as a physician or surgeon. The bill provides that an applicant for licensure as a physician or surgeon will satisfy the postgraduate training requirements in the law if the applicant graduates from an oral and maxillofacial surgery program accredited by the Commission on Dental Accreditation, graduates from a medical school associated with a training program that's accredited, and completes 24 months of postgraduate training at a program accredited by the Accreditation Council on Graduate Medical Education. The current law, as you heard at the public hearing, has a statutory requirement that applicants must have completed at least 36 months in a graduate educational program. And as you heard at the public hearing, there are some applicants who are qualified with dual degrees with a dental degree, who also seek licensure as physicians, and based on the certain sort of timing of their training, the statute does not allow the granting of a license because the statutory interpretation is that they don't have the required 36 months of postgraduate training. So you heard testimony about that and the board's position that the 36-month requirement in current law has not been met. The Board of Medicine did provide testimony in opposition to the bill and raised some concerns about the changes proposed in the bill as drafted. And the committee did request that the board go back and take a look at proposing or suggesting an amendment in place of the bill for the committee's consideration. And I can share that proposed amendment that the board submitted for the committee's consideration now. I'll pull it up. So I had shared this with the committee yesterday, but this would, this is the statutory provision in current law related to postgraduate training. So the board's suggested amendment would replace the language in the current law with language that would give the board discretion to consider training that occurs following graduation from a dental school accredited by the Commission on Dental Accreditation, or its as part of a license application. So this is the suggested language. The board believes that this would allow them to consider the application of the gentleman who testified at the public hearing. But I would note that this is discretionary on the part of the Board of Licensure in Medicine. So it's like the process that is provided in LD 1660, but it's not, it wouldn't be mandatory that the license be granted. So I did want to point that out to the committee. They could make a decision on a case-by-case basis and consider this additional training as part of the licensure application. So I'll stop sharing. I do think Mr. Smith is here if you have any questions about the proposed amendment language. And I do know that you also received some additional information by email from Dr. Cooper as well since the public hearing.
Yep. Okay, is there further discussion from the committee? All right, I will note that I wasn't able to read Dr. Cooper's information as I received it after we started chairing the committee, after I started chairing the committee meeting today, but I did ask Mr. Patterson, who was one of the folks who testified, to reach out to Mr. Cooper on my behalf last night, just because I know Mr. Patterson, and he's the brother-in-law. And so he was able to confirm that Mr. Cooper felt, or Dr. Cooper felt comfortable with this language and with the amendment, and that the board would likely proceed accordingly under, with this authority. So Dr. Cooper seemed positive, have a positive reaction to the Board of Medicine's counter proposal here. Are there other comments? All right, seeing none, I'll entertain a motion. Representative Connor, would you like to make a motion?
Absolutely, Madam Chair. I would love to move that or 1629 ought to pass, and I believe it says amended, correct?
Yeah. Seconded by Representative Evans. All right, is there any further discussion on the bill? Seeing none, the clerk will call the roll.
Representative Quint. Absent. Representative Connor.
Yes.
Representative Bleier.
Yeah.
Representative Morris.
Yes.
Representative Matheson.
Yes.
Representative Evans.
Yes.
Representative Arford.
Yes.
Representative Malrano.
Yes.
Representative Brooks.
Yes.
Senator Stewart.
Yes.
Senator Brenner. Absent. Representative Tepler.
Yes.
Senator Sanborn.
Yes.
11 yes, 2 absent.
And I just raised one thing that I forgot to when I was presenting it, and I meant to. I didn't know if the committee was interested in adding an emergency to this
I would like to.
legislation. I forgot to mention that possibility. This is drafted as, general effective date. And I think until the statute is changed, there's really no discretion on the part of the board to grant the license in the interim. So
Great. I would like to deem that part of the original amendment with the forbearance of the committee, so we don't have to vote. Is there anyone who objects? All right, perfect. It's a vote. Great. Okay. Thank you, Colleen, for that catch. That's going to really help this one, doctor, and hopefully help us attract other maxillofacial surgeons that we might need to serve the people of Maine. So thank you. All right. The next bill is LD 1622, which is Senator Vitelli's bill related to retirement savings. Colleen, you can go ahead and pull up your analysis.
sorry about that. I kicked
No
myself
worries.
out. There we go. So this is LD 1622. This is a bill that would establish what's called the Maine Retirement Savings Board to establish and administer the Maine Retirement Savings Program. It would designate the Treasurer of State as the chair of the board and place the program under the oversight of the Office of the Treasurer. The bill requires the board to develop a voluntary program to offer individual defined contribution retirement accounts for persons employed in the state who do not have access to a qualified retirement plan through their employers or who are self-insured. This is a bill that was considered in the 129th legislature. It was actually considered in previous legislatures as well, but most recently in the 129th as LD 594. So returning committee members might remember the discussion of that bill. It was reported out of committee with a divided report, but was not taken up in any special session before termination of the 129th legislature. As amended by the majority report, LD 594 would have directed the program to be overseen by the Maine State Retirement System rather than the Office of the State Treasurer. LD 1622, as drafted, directs the Office of the State Treasurer to oversee the program, and that was the how LD 594 was drafted originally as well. So it sort of returns to LD 1622 returns to how the bill was originally presented to the committee. The sponsor, Senator Vitelli, has suggested a few technical amendments to the language as drafted, which I've outlined for you here. And then I also did receive by email late this morning some additional suggestions from Senator Vitelli to make some changes to the legislation. The primary one of which would be to replace the language requiring the treasurer to be the chair of the board with language that would allow the board to elect a chair, and then some other sort of technical changes to the sort of qualifications of board members. So I'll outline, just want to make sure I noted those for the committee, and I can pull up the email to be more specific if that is useful. As drafted, the bill also would include a provision to provide initial funding for help with implementation. It provides 1.6 million in one-time funding from a multi-state settlement agreement. The Attorney General currently oversees the distribution of those funds, and they indicated in written testimony a support for this proposal, but it suggested a technical amendment to the language in Section 5 that would properly identify the case in which the settlement agreement was entered into. So the analysis just sort of notes the language that should be in Section 5 if you move forward. You did get a number of written testimony and testimony at the public hearing about the availability of individual retirement accounts through employers and also individually. that in the private market and whether or not a public-private partnership as outlined in LD 1622 is necessary. And some testimony also considered modifying the program to more of a marketplace model, which would allow the private market to access the program and all eligible private financial services could participate. One of the other states that has implemented such a program has sort of used that marketplace model, if you will. You also had some suggestions that you consider the experience and costs of implementing the program in other states, and think about what the ongoing administrative costs in the state would be and to employers. Issues related to ERISA preemption were also raised. The bill itself contains language prohibiting implementation if the board determines that the program would be preempted. I did want to note that there were pending challenges in other states to their retirement savings programs when the committee talked about this legislation last time, but there was a recent decision just in early May to a challenge to California's law. In the Ninth Circuit Court of Appeals did issue a unanimous decision holding that the ERISA did not preempt the California law. I would note that Maine is not in the Ninth Circuit, so we're not subject to that holding. But I did want to note that at least one of the primary challenges related to ERISA was upheld related to the California program. And then I just linked to some websites that provide some information about state-sponsored retirement savings programs. At the end of March, there are currently, I think, 5 programs, and I noted the states here that that are open and sort of enrolling workers through their employers. And all of them are really, I guess they're not all identical in how they have been developed or implemented, but the programs are currently operating. And we don't yet have all of the fiscal information, although, as I noted, there's a provision allocating 1.6 million in one-time funding that's part of the bill. I'll stop sharing. I do think perhaps Senator Vitelli is here as well, if you wanted to hear from her, and she could talk about some of the additional suggested amendments that we received if you're interested in hearing about those. But as my understanding is that they are all really sort of technical in nature. I'm happy to sort of go over some of the specifics. The bill, as you talked about at the public hearing, sort of has stages for implementation based on the size of the employer as to how the sort of mandatory offer of the retirement savings program would be required to be made by those employers, and employers that have 4 or fewer employees are not required to are not mandated to offer this to their employees, but the language of the legislation does permit them to if they chose to do so. I'll stop there.
Okay, committee questions for Colleen. Committee discussion about the bill. I know that there were some questions about sort of whether the money would be sort of safe from being reappropriated by some other government entity. And I know we've got an expert here who could kind of speak to why that's not possible, but if that's already been resolved and folks don't have that question, then I won't call him in. But if you do have that question, I'd be happy to bring him in. Representative Bleier.
I don't have a question for the gentleman. It's a different question. So if you want to continue on that concept and then come back to me.
Go ahead. I didn't see any other hands go up, so go ahead.
All right. So so I'm really in favor with the theory of what this is trying to do. I really am. One of the concerns I had is when Dan Bernier spoke about the ability for the fund to be solvent. And so we all received an email from Dan Bernier explaining, he gave us 3 different examples of California, Illinois, and Oregon. And most programs, the lady that spoke at the committee was saying that, it was about a 0.75% fee for managing that fund. A lot of brokerage companies, if you can do 1%, that's on the higher side. So even if you did use that 1% model, a lot of these funds, even though they have a lot of money in them, if you divide it by the amount of the participant, the average amount of money per person in each fund starts at $425 to $947. At 1%, you're looking at $4.25 to $9.47 to manage that fund for a year. And also, that's about a 30% dropout rate where people are calling in. So the problem I'm having is that every year they're going to have to opt out, right? So they opt out at the end of the year, they're opted back in, they have to opt out again. I look at that as far as employment, the amount of time it would take to do that. If you're paying $4.25, you cannot provide the staff that's going to be needed in order to just run this program. So the theory of insolvency, I think, is really, really real. And so what happens then if it becomes insolvent? Does the state then kick in the funds to keep this program going? What happens at the point if the fund cannot be solvent and cannot be managed by the investment houses? What happens at that point? So to me, that's the real question that I would like to have answered. And having said that, I think that although I think this is a great idea, I don't know if this is really the vehicle for it. I would rather see something to the effect in the sense of companies would get a tax reduction to provide some kind of investment vehicle if they're not already providing some type of 401k. I think that would be a better way to tackle this, but that's just so, but that main question is my real concern.
Okay, I'm going to invite in Mark, I'm not sure how to say his last name, Erie or Irie, who I think would know more about the question of solvency and how that would work. So I'm going to bring him in now. Good afternoon. Can you hear us? Good afternoon, Mr. Erie. Can you hear us? If you can, you need to unmute yourself in the lower left-hand corner of your screen so we can hear you.
Right. Can you hear me now?
Ah, perfect. We can. Wonderful.
You.
You're welcome to activate your camera if you can. And if not, that's fine. We can hear you just fine. There you are. Wonderful. So could you introduce yourself to the committee?
Sure. I'm Mark Every. I'm a non-resident senior fellow at the Brookings Institution in Washington and a visiting scholar at the Wharton School, University of Pennsylvania. I was formerly in charge of overseeing the regulation of the private pension system in the U.S. While serving at the U.S. Treasury Department as a senior advisor to the Secretary of the Treasury. And I am delighted to be with you and happy to try to address your question, Representative Bleier, if that would be helpful.
Please go ahead.
So these programs are designed to really put virtually no burden or cost on the employer so that the employer would not be left holding the bag under any circumstances. The programs essentially use private sector financial services entities to run this retirement savings program for essentially the people who are left out of the 401ks today. Typically lower income, African-American, Latino people who are disproportionately not in the current system. And the solvency should not be has not been a problem in the three similar programs, California, Illinois, and Oregon that you mentioned, Representative Bleier. They are intended to be eventually self-sufficient, financially sustainable, once the accounts get to the point where a reasonable fee, as you pointed out, something south of 100 basis points, maybe a fraction of 1%. A reasonable fee is all that would be permitted to be charged. And over time, as the accounts get larger and more people participate, and there are about 1/3 people now participating in these automatic enrollment IRAs in those 3 states and growing all the time, they'll become self-sustaining. The states have not had to kick in a lot of money, and the programs are so simple. They're really bare bones retirement saving for people who don't have access to that 401k plan that we would like employers to adopt. To your point, Representative Bleier, the idea of a tax credit for a small employer that has not adopted a plan in order to encourage them to adopt a 401k or something similar is a great idea, I think, but it's one that's already in effect. Congress is providing that kind of tax credit for small employers in all 50 states who decide to adopt a 401k or a similar small business retirement savings program. And this proposal from Senator Vitelli would essentially pick up where that leaves off. We've gotten some more small businesses to use that tax credit, to treat it as a good incentive to sponsor a plan, but not enough of them. And so most of the people we're concerned about are still who have been outside the system, don't have access to a plan at work. In the wake of the tax credit, which has helped some, most of them still don't have a plan at work. So this is a kind of fallback, a safety net for those folks, which is very private sector friendly. And I say this because I essentially designed this program, and I've spent half my life in the private sector advising employers on how to sponsor these regular plans like 401ks and pensions. And I do think that the evidence in California, Illinois, and Oregon is that these things work, they're low cost, they're very simple and straightforward, and they help encourage small businesses, instead of doing this, sort of participating in this payroll automatic enrollment in IRAs, they actually make it easier to sell plans to small businesses. If you're a financial institution and you're marketing 401ks, this makes your life easier because you can say, Maine has a requirement that if an employer has at least 5 employees and they've been in business a couple of years, they can have a plan. If they don't have a plan, then they should at least let employees use their payroll system to save. And employer, you could adopt a plan which would be even better than this, and use this as an occasion to take that plunge and set up a 401k. And that has been happening. We have anecdotal evidence in the other states that have tried this, that it encourages some employers to adopt 401ks, but it also enables all these hundreds of thousands of employers who won't adopt a K to have saving at work in an easy way.
Representative Bleier, is your hand up to ask another follow-up? Go ahead.
Thank you, Madam Chair. Thank you, Mr. Ivey, for being here. So some of the key points that you brought up that I'm still, I'm baffled with it. You mentioned that you're the one that's kind of, instilling this program moving forward. And so when people start applying or putting money in to this program, it takes a while for it to be self-sustaining. And so the question is, where does the resources come from while it's becoming self-sustaining, number one? And number two, you mentioned the point that, states don't really have to kick in a lot of money. So that tells me that they are kicking in money. And so are the states kicking in the money? Well, it's not self-sustaining. So the fiscal note on this is $1.6 million.
Right.
Is the state going to be $1.6 million this year? And if it's not self-sustaining, more money, or that's it? The state will never have to appropriate any further funds to this program moving forward?
Well, I'll defer to Senator Vitelli on that last question, but I will say, and please don't, I'm not the one who's spearheading this whole movement. I developed the concept, and the states on their own, many people in many states have found it to be useful. ARP has been in support. Many folks, including in the private sector, have been very much in support. I do think that what happens that makes it financially responsible and fiscally sound is that the private sector recognizes that this is a good investment in having hundreds of thousands, millions, ultimately more people saving. And they enter into long-term contracts with the state. The board that runs this, chaired by the treasurer, does RFPs, they get bids, and you use the competitive bidding process. So in California, Illinois, and Oregon, private sector record keeper, administrative firms, TPAs, have bid on this and have gotten the business and have entered into long-term contracts with the states because they recognize that the financial projections show that this should break even and then be fully self-sustaining within a reasonable time, but not within 1 year, like many other good long-term investments or even medium-term investments. And so both the record keeper firms and the financial firms like BlackRock, Schwab, others, including smaller employers, smaller financial providers, they've also been entering into contracts with the states to provide the investments, to provide the IRAs, and it's been working. It's been working in these other states. Sometimes there's a loan from the state instead of an appropriation, and the loan is intended to be repaid over several years. But it seems to be working well. The model is working, and that's why recently additional states have adopted the same kind of model that Maine is considering. Virginia, Colorado, New Jersey, New York City, possibly soon New York State, and Maryland and Connecticut have all adopted this, in addition to the 3, California, Oregon, and Illinois, that have not only adopted, but started to implement it over the last few years.
Great. So Representative Bleier, did you want another follow-up?
Can I have a follow-up, please, Madam Chair?
Sure, go ahead.
Yeah, so one more, thank you, Madam Chair. One more follow-up. You're saying that this model has been implemented in different states. How long has this model been active in different states?
Great question. In Oregon, it's been 3 years plus, if I'm remembering correctly. It's between 3 and 4 years, I think 3 and a fraction. In Illinois, it's something like 2 to 3 years, 2, I think. In California, they're in year 1. 140,000 people are already saving under this program in California, and roughly 100,000, give or take, in each of the other 2 states. So you've now got about 1/3 US workers who are, for the first time, saving on a tax-favored basis. These are IRAs, these are Roth IRAs. The individual gets tax-favored treatment. There's even a tax credit for lower and moderate income people at the federal level that this program can take advantage, that the state take advantage of. The state does not have to fund any of this tax-favored treatment. We're taking advantage of federal tax preferred savings vehicles, the Roth IRA, the tax credit for lower and moderate income people. So it's very private sector oriented, really. The money is run by the private sector. It's just trying to create a starter account, basically, for people who will ultimately, hopefully, roll this money right into 401ks, if they're fortunate enough to have an employer who sponsors one. And our hope is that the employers that are participating in this will realize after a little while, maybe right at the outset, that they could provide a 401k for their people, wouldn't cost them too much. They get that kind of tax credit for doing that you mentioned, Representative, which is, a valuable thing for small businesses. And so the hope is that this will actually push more employers into sponsoring plans, more and hundreds of thousands or millions of more people, American workers, into saving in the private sector.
Representative Connor.
Thank you, Madam Chair. Thank you, Mr. Irish, for being here. I'm glad you had brought up the other two states. We got some testimony regarding Connecticut and Maryland.
Yeah.
And those two states seem to have enacted this back in, I think, 2016. It was what the testimony said. Maybe you can give us more information, but can you give us a status on those two states? We've talked about the other three, and they seem to have been enacted much more recently. And these two states have been acted, back 2016, but they don't seem to be doing anything yet. Can you speak to them? Was there something different that these two states did? I mean, you're looking at 5 years now, and they still don't have the funds to keep the programs rolling. Can you just speak to that a little bit?
Sure, and I appreciate, Representative Connor, you're asking that question because it's obviously really relevant. The 3 states that are now implementing adopted the legislation years before. It takes 2, 3, 4 years typically for a state to dot the I's, cross the T's, decide exactly how they want to do it, to put out the RFPs, to get the private sector bidders, to select who the best bidders are, and then to work with those private sector providers to set up the program. So California, yeah, they passed their bill. I think it was signed into law September of 2016. They've been going for a year now. So it took them maybe 3 to 4 years to set it up. Oregon and Illinois, I think they passed theirs around that same time, maybe a year earlier. And and in Maryland and Connecticut, they're just taking a little longer. Maryland, I know, is very thorough in trying to figure out what the best state-of-the-art arrangements will be. And on a very private sector oriented basis, they've talked to dozens of small businesses and small financial providers, startups in the 401k world and in the IRA world. They're trying to really do sort of a world-class version of this, yet, make it as simple as possible. And they say that they're about to launch next year. They were saying late 2021. I think COVID has set, frankly, everybody back by about a year and a fraction from where they would otherwise be. California, Oregon, and Illinois got going, actually didn't just pass the law, but implemented, stood it up, and started helping people save before COVID started. And that's probably that's adding, maybe a year and a half or so to Connecticut and Maryland's efforts. But I know in Maryland, I've talked to them recently, the chairman of the board there says they're closing in on it. They're selecting bidders, I believe, at this stage. They've gotten RFPs. There's been a tremendous amount of interest from the private sector. And the folks in Colorado are moving forward. They just passed the law some months ago. New Jersey, likewise, they just passed it. They're moving forward. Virginia just passed it a few weeks ago. They're going forward. New York City just passed it in the state assembly. New York State just passed it. They're going to the Senate. So each state is at a different stage, but it's taking something like, without COVID, maybe 2 to 3 years between the time the law is signed to the day that money starts to move and those private sector entities start to help people save.
Thank you. Madam Chair, may I have just one quick follow-up? So since you seem to be the one that has the most experience and boots on the ground, if you will, have you experienced or heard from any of the businesses that may have, what's their feedback? Some of and I'm talking about the smaller businesses, maybe only a handful of employees. What has been their experience? What's the feedback from them that's being heard throughout the country?
I'm really glad you asked that question, Representative Connor, because obviously that's one of the things we care about the most. Is this good for small business? Does it help small business? Does it burden them and generate costs or risks for them? Very positive feedback. The Pew Charitable Trust, and let me hasten to say, I'm not the only one who's got a lot of experience with this. Pew Charitable Trust has been very involved. ARP has been hugely involved, including in Maine, supporting this idea. Various other organizations, Georgetown University, and many others have been involved and supportive. Pew did a survey of small business owners, to your point. And what they reported is that 3/4 of them said that they were fine with this. And that 4/5 of them said it was zero cost to the small, out-of-pocket cost, zero out-of-pocket cost to the small employer. The cost to the employer is essentially that you have to take a little more time to focus and make sure that you're complying. But it's very little, because this is just more payroll withholding, the way a small business has to withhold income tax, state and federal, and FICA and so forth. This is another withholding that they do, and they send the money to the private sector record keeper that the state contracts with, to the individual's IRAs. It's not a heavy lift. That's what the small business owners have been saying, that this isn't a big problem. Yeah, it takes them a few more minutes, each pay period, but not a lot. And the satisfaction and appreciation of their employees, when the employees see that, my small business is actually helping me save, is well worth it. So we're getting very positive, and I would be happy also I'll send Senator Vitelli a copy of that Pew survey of small businesses that she could forward to you and the whole committee if you wish.
Thank you, Mr. Ari. Thank you, Madam Chair. That's all I had.
I'm on mute. Representative Flyer, go ahead. I don't do that very often. Go ahead.
Thank you, Madam Chair. Thank you, Mr. Ivory. So you mentioned the 3 states that are already implementing this program. Some are a little over 3 years, 2 years, and 1 year. Are those plans self-sustaining now? Do you know?
I don't think that without the long-term contracts that they have with their record keepers, that the programs could have broken even in 1 year. I don't think that they've reached solvency in terms of repaying whatever the initial investment was in a few staffers and putting out RFPs. But the initial investment's been very small in these states. It hasn't required a lot of staff. It hasn't required a lot of infrastructure. And I think that they're on a path, as I understand it. We'll be happy to, follow up with you. But my understanding is that they're all on a path to reach solvency, and that there isn't exposure. There isn't sort of worrisome financial exposure for anyone involved. That in some cases they got a loan from the state and they're either going to repay it in a couple of years, or whatever the particular circumstances are, we can update on that. But I haven't been hearing things from the state saying, oh, we're in financial trouble, but rather, yeah, everyone knew that in order to run a savings program without any subsidizing it in any way, you need enough balances to get some economies of scale so that you're earning more, in terms of interest and dividends and capital gains than the reasonable cost of just administering the thing, administering the accounts. And I think the cost of administering these accounts is very low. It's really efficient. Again, because we're not using the government, we're using the private sector. And so it's an efficient program. It's one that looks like it's on track to be financially as projected, which means that, I think, frankly, if the states were to subsidize and invest a certain amount in these, it would be well worth it given the cost savings to the state in the long run. There's less social programs, there's less public assistance, less Medicaid costs ultimately for the state, less, welfare type programs. I mean, this is trying to help people get on their own feet, be financially independent sooner, and actually save the state money in the long run. So, for 1.6 million, heck, even if it were a lot more than that, I think the return on investment for the states is major. It just takes a few years to realize that. And in the meanwhile, happily, because we're using existing vehicles, right? IRAs, there's tens of millions of them in this country. And, our private sector knows how to run IRAs, and we know how to do target date funds and, investing in diversified stocks and bonds, of course. And some of you folks are experts in that and experienced in all that. So this is really just taking the private sector and relying on their success and experience in doing all this. And that's why it's working in the other states. And that's why all these other states are rushing into, not rushing in, but are moving briskly to adopt similar programs.
Thank you.
Mr. Ivory, I wonder if I might have a clarifying question that might get to what Representative Bleier is driving at.
Sure.
Which is that you've spoken about the long-term contracts with the record keeper and the financial firms in the private sector. And my understanding is that those long-term contracts actually sort of insulate the state from sort of the very risk that Representative Bleier is concerned about. In other words, if BlackRock or Schwab or Merrill Lynch or whoever wins the RFP to participate, to be the holder, the third-party administrator of this fund or of these individual accounts, that they say, we will accept 60 basis points or whatever it is, right? And it's some number less than the total fee, right? So it's 60 basis points or it's 58 basis points or whatever, and that's written into the contract. And for sure, in the first year, Schwab or whoever wins the contract is subsidizing the program, right? They can't possibly be covering their own administrative fees for the 55 cents. But they knew that when they put their RFP in, and they said, but this is worth it for us because we're going to get all these new customers. They're probably going to, then think of all the other ways that those customers might be valuable to them.
Right.
But that they're going to also know that those accounts are going to grow over time, and that eventually that 55 basis points is going to be on a bigger number, or at least a bigger pool of accounts that they can administer very cheaply, because it's a pretty simple account that they already have the technology and platform and electronic access and all of that that's totally scalable and doesn't have a cost that scales with the number of accounts, right? It's not 4 times more expensive to administer 400 accounts than it is to administer 100 accounts, right? Because you've already built the process for it. So the only question, I think, is whether whether the board does a good job of negotiating or of picking that first RFP to ensure that they've got a long-term partner in place who's going to help them grow these accounts, manage them appropriately, and that they save enough of that little basis. You know, I guess in my example, it was 12 points or 15 points or something above what the private sector partner is taking, so that they've got the staff that they might need that actually works for the state, which is a pretty small, a few employees, and that they have that little fraction that can then pay back. In Mr. Ivory's example, though it's not the setup we have here, but could actually pay back to the state the startup costs over the long term, based on the little fraction of the fees. And then once those startup costs are paid back, they could lower the overall fees and return even more of the returns to the individuals who have these retirement plans once the plan has become mature, once the overall retirement setup has become mature. Mr. Ivory, have I explained that well?
You sure have, Senator. I mean, that's exactly right. And if I may just tack on to that, and Representative Bleier, you very appropriately brought up some examples. You know, the fees might be 0.75% to 0.75, 75 basis points. It might be less. You know, if it's 100 basis points, it's starting to get, to the point where you hope you can get something more efficient than that. The reason that you need a little time, as Senator Sanborn was pointing out, is year one, you start with somebody who hasn't saved before. They put in, $50 a pay period, let's say $100 a month. The end of the year, they got $1,000 or $1,200. That $1,000 balance in an IRA is going to cost obviously something to maintain, to set up the IRA, to report to the person their balance, to deal with the investments, even though it's all bare bones, as simple as possible. Might be $30 or $40 a year, might be $20. That, let's say it's 20, that's 200 basis points on $1,000, right? Well, that sounds, ridiculous. That's off market, right? That's really expensive. But if you look at what's really going on, they're just saying, hey, we got a good deal with private sector firm. It's going to charge $20. Some charge $40 to manage an IRA for the year, because they hope, as the senator was saying, to get long-term customers out of this and lots of savings as it grows. That's going to be a loss leader in year one, because you're going to be paying $20 of costs to maintain an IRA that has only $1,000 in it. And so what's it going to earn? If it's earning a reasonable rate of return, it's still going to be, lagging behind. You're going to have to really wait until it gets to a size where it's going to be $10,000. It's still going to cost, the fixed costs will be about the same. The variable costs will be a little more, but you'll start to break even on an account once it gets to a reasonable size. And here, unlike a lot of 401ks, we're not targeting the people who have a lot of money and who can, start out like some of us, putting in a substantial amount every year. These folks are the people who can barely save anything, and some of them can't, which is why a bunch of them opt out, and that's a good thing that some of them can't afford to save anything. But the ones who can, they're saving an average of about $1,200, $1,300, $1,400 a year, a little over $1,000 a year. And that's, over a few years, you can start to break even running an IRA for a small saver like that. Someone who plunks in, the $19,500 right at the get-go, it's easy to break even on that. That $20 to run or $40 to run that IRA, it's easy for the investment returns to cover that. These guys, the little guys we're catering to, they've always been left out of the system because they're too small to to easily make a profit on them in the short term. And that's why this is a longer term, medium term oriented, as Senator Sanborn said. And over a few years, these accounts grow and the earnings start to exceed the fees. And that's when, you know, you're breaking even and recovering your costs. You know, over the long term, we think this will be a big contributor to our 401k and IRA system, right? You know, the hugely successful private sector retirement savings system that we've got, and that these people will many of them will turn into really good customers for Schwab or BlackRock or the community bank or the small insurance company, you know, the people who provide these benefits. And these folks can roll over to an IRA that's offered by anybody. You can have a community bank in Maine that has an IRA that goes to these people and says, you know, this program primed the pump and it got you starting to save, but you could roll over to our IRA and save in our IRA for the rest of your life, because now you've got a saving habit. And that's what we really hope. It's intended to really prime the pump and serve the private sector saving that helps workers and, you know, providers alike and small businesses.
Representative Connor.
Thank you, Madam Chair. A lot of what we're talking about is based on the assumption, I assume, that the vast majority of people will be contributing. Do we have data on some of these other states of what the opt-out rate is right now?
Yes.
And, you know, obviously if these RFPs are going out, they're based on a certain number of people contributing, and the state is going to be locked into those contracts. And if more people opt out, then what happens? So I'd like to know if there's some data out there of how many people are opting out.
Yes, Representative Connor, there sure is. What we're seeing right now is about 30%. Some states it's in the high 20s. Some states it's a little over 30. Right now, about 30% in these 3 states are choosing not to participate out of all the employees who are eligible, which is pretty good, actually. In the 401k world, which I work with a lot too, when we automatically enroll people the way they would be in these programs, they can opt out. If they don't opt out, they're saving. The 401k world, we've got about a 90% participation rate. So like 10%, 1 out of 10 might opt out. Maybe 15% might opt out, something like that when you auto enroll them. The difference is the average wages and salary of people who are participating in 401ks, it's like 2-3 times these people. And so those folks can much more easily afford to. These are people who are, you know, living hand to mouth, paycheck to paycheck. And it's fantastic to get 70% of them saving for the first time ever. And kind of reassuring to me, frankly, that you have a reasonable proportion opting out. Because we don't want to force people to do anything here. This is based on, you know, basic sort of free choice. The individual can save or not save as they choose. And if they want to save a different level, you know, the default typically is 5% of pay goes into the plan. You can opt out completely. You can also opt to say, you know, this year I can only do 1 or 2%, but I want to kind of get it going. And so this is based on voluntary choice for that individual to contribute as little or as much as the IRAs, you know, will permit. You know, up to $6,000 a year, $7,000 a year if you're over age 50. These people, most of them can't get near that, but it's sort of reassuring to see, you know, the ones who can't do it are not being forced to. They're really getting the message that it's your decision. And the 77 out of 10 who feel they can do it, for the first time in their lives, they're starting a habit of saving.
Excellent. Thank you. Thank you, Madam Chair.
Mr. Ivory, I also want to just address a different sort of I think, assumption that was baked into Representative Connor's question there, which I think might not be right, which is that if a lot of people opt out, somehow the RFP would then put the risk of that back on the state. And my guess is that that the long-term contracts that are entered into with the private sector wouldn't put the risk of a lot of opt-outs back on the state, that it's really the long-term contract says, you get what you get. And you get this many basis points on the amount of assets that actually flow through to those accounts. And if more people than we expected opt out, then it's going to take you longer to convert that to the green side of the ledger, for you, Mr. Private Administrator. But if maybe more people will opt in than you expect, will not opt out than you expected, and then you get to keep that extra amount of fee as well, that you weren't anticipating, or the savers will save more than you anticipated in your model. And, so all of the risk really, it stays with the private sector in that sense. Isn't that the case?
That's absolutely right. The state has provisions in the bill that protect the state. The state is not exposed here. If Schwab or a Census, which is the record keeper for the 3 existing states, or BlackRock or some other private sector firm loses their bet, they're making a bet that this is going to be profitable over time. If it turns out not so, if you had 100% or 90% opting out, then yeah, they would be the ones left holding the bag, the private sector for-profit firms that are making the bet that this actually will turn out to be profitable and self-sustaining. The state is protected. The state is not, sticking its neck out here. And whatever money it invests in this, a small amount like what you're contemplating compared to the tens of millions, hundreds of millions that the private sector invests in deals such as this. The state is really leaving the risk to the private sector firms. And in a way, the market is deciding. I mean, if the BlackRocks and Schwabs and other private sector firms look at this and say, this will never work, they won't bid. And California, Oregon, and Illinois never would have gotten going. But folks are bidding, and the programs are working. And Senator Sanborn, you're spot on. I mean, the risk is on the private sector firms who are, making their business judgment that this is worth a go.
Great, thank you. Are there any additional questions for Mr. Ivory? Okay. Thank you so much. I think that was actually really, really helpful. And I know I learned a lot and have a much clearer understanding of it. So thank you so much for being with us.
My pleasure. And I'm happy to follow up, to the extent that any of you, particularly if Senator Vitelli wishes, I'm happy to follow up with any of you. And in fact, I'm even willing to talk to you offline if any of you would like to, continue discussing this and looking into the experience and considering the arguments, that folks have been making or questions people have been raising. I'm at your disposal.
Thank you so much. All right, I'm going to send you back to the attendee space. So you're going to go back through the wormhole for a minute here, and then you'll be able to hear us again.
Great.
Okay. Is there committee discussion or the need for a corner caucus? Representative Connor.
Thank you, Madam Chair. I know I asked a lot of the questions, and I don't know. I think most of them were answered. I'm all in favor of helping folks save money. I'm a little hesitant on the on the business owner side of it being required to. I would like to see the minimum threshold maybe from 4 up to 10 or so, but that's if we can't get that, I understand that. I will keep an eye on this, but I plan on supporting this bill. But I just wanted to get that out there, that it is something that I want to keep an eye on. And if the committee would consider upping the amount of employees that a business has, I would love to have that discussion. But if not, I still plan on supporting it.
Thank you, Representative Connor. I think it's a ramp as it's drafted now. So it would be larger small businesses. They're all still small businesses, but larger small businesses first, and then ramping down over time. So I almost feel like we could leave it in how it's drafted, and then there's always the opportunity for us to sort of come back, revisit it, and stop the implementation ramp at some point if we, heard from businesses that were smaller that they wanted us to sort of not require it below 10 or whatever. So that's how I would suggest we handle it, because it does have that phase in process, so we'd be able to get more experience. Okay. Are there other comments on the committee? Representative Malrano.
Thank you, Madam Chair. So I'll be supporting the bill as well. And I honestly don't think it gets at the heart of income inequality and economic inequality, but it does give workers who probably otherwise aren't saving for their retirement, it gives them an option to do so. And so I will be supporting it.
Thanks, Representative Malrano. Are there any other comments? And as I've said before, I just think it's so important for small businesses to be able to utilize the automatic enrollment feature of this with the opt-out, which is right now only available to large businesses that can afford a 401k, rather than under the simple IRA format. That's the type of savings vehicle that small businesses like mine have available to them. I have right now a de facto 60% opt-out rate among my employees, but it's not because they opted out. It's because they have never gotten their act together to opt in, which is a much harder task. And so, I think that's the uphill battle that I've been fighting as a small business owner, and why I've been so supportive of this bill, even though it wouldn't apply to me, because I already have a different retirement vehicle. So I'll just continue to push on that other retirement vehicle and try and see if I can improve my enrollment. But I'm very pleased to support this bill and streamline the process for other small businesses and their employees. Senator Stewart.
Thanks, Madam Chair. I just wanted to say, as a co-sponsor of the bill, that I obviously am supportive of it, but wanted to voice vocal support for it as well. I think that we do have a problem, particularly with my generation, and not saving for retirement. And ultimately, if substantial steps aren't taken in that regard, I would like to see too an initiative made on the educational side as well, but that's for a different committee, because it is important. And I worry that so many of my peers aren't taking that responsibility seriously, and ultimately that responsibility will then transfer to different forms of government as they get later in life, one way or the other. So I think that this is a way that, with minimal, certainly minimal impact from this on the state side in terms of dollars, but with the oversight of the board, I think this makes sense. This is the right approach to address a real problem. And so I appreciate the sponsor bringing it forward, and we'll be supporting the bill.
Thank you, Senator Stewart. Representative Tepler.
Thank you, Madam Chair. And I just want to say that I agree with Representative Malrano. I will be supporting this bill, but I'm not a strong believer that the issue around savings has to do with generations. That I personally believe that a lot of it has to do with the fact that relative pay has decreased for working people. And that really concerns me. And I think that people are being encouraged to save helps, but I also think that paying them a better wage helps.
Representative Arford.
Yeah, just very quickly, I will support this bill. I am grateful to the people who have brought it forward. I think there's many reasons that prevent people from starting a program like this themselves. And I think that there will be people out there that will be appreciative, the fact that this is available to them now. So thank you.
Representative Barford. Okay, seeing no further hands, I'm not sure we have a motion. So ought to pass, I'm going to move ought to pass as amended. We've been on this bill for a while, so I just take that shortcut and say ought to pass as amended. Representative Tepler is seconding the motion. And is there any further discussion? Seeing none, I'll have.
Can I just clarify? Yeah, you're just interested in making the technical amendments that Senator Vitelli has identified in the Attorney General? Okay.
Yep, the treasurer, the attorney general, and the sponsor, I think, had all suggested some different amendments, but they're all very technical, I think. And so the clerk will call the roll.
Okay. Representative Quint.
Absent.
Representative Connor.
Yes.
Representative Blyer.
Yes.
Representative Morris.
No.
Representative Matheson.
Yes.
Representative Evans.
Yes.
Representative Arford.
Yes.
Representative Malarongo.
Yes.
Representative Brooks.
Yes.
Senator Stewart.
Yes.
Senator Brenner. Absent. Representative Tepler.
Yes.
Senator Sanborn.
Yes.
10 yes, 1 no, 2 absent. Is there a minority report?
Yes, it's ought not to pass.
Thank you.
All right. Great. Next up is LD 1268. This is Senator Stewart's bill regarding step therapy and prior authorization for drugs related to severe mental illness. Colleen, I don't think we've had a work session. We've noticed it a couple times for work session, but have we actually worked it?
We have not. No. Would you like me to go through the analysis? Okay.
Why don't you do the analysis for us then? Okay. Thank you.
I'm happy to. I don't think we ever got to it. I think I've shared the analysis a couple times, but I don't think we've ever actually gone through it. So I'll try to do it really quickly. As it's drafted, LD 1268 prohibits an insurance carrier from requiring prior authorization or step therapy protocol for prescribing medication to assess or treat an enrollee's serious mental illness. The provisions would apply to health plans issued or renewed on or after January 1 of 2022. I did want to note that there are some provisions already in current law related to prior authorization, and just let the committee know that generally prior authorization requests for non-emergency services must be responded to by carriers within 72 hours or 2 business days, whichever is less. And committee members from the 129th legislature will remember we talked about prior authorization and made those changes to prior authorization statute as part of legislation last session. There is a provision in the current law that prohibits prior authorization for medication-assisted treatment for opioid use disorder for the prescription of at least one drug for each therapeutic class of medication used in medication-assisted treatment, except that carriers may not impose any pre-authorization requirements on pregnant women for a medication-assisted treatment. And then there is also a provision that specifically relates to prescription drugs that says that with respect to requests for clinically appropriate prescription drugs that are not otherwise covered under a health plan, the carrier is required to provide for expedited review, which is within 24 hours of prior authorization requests in exigent circumstances. And the statute defines what those are as when an enrollee suffering from a health condition that may seriously jeopardize the enrollee's life, health, or ability to regain maximum function, or when an enrollee is undergoing a current course of treatment using a non-formulary drug. There are also step therapy requirements in the current law, and step therapy is a protocol that would require a specific sequence for certain prescription drugs for a specified medical condition that are medically necessary for a particular enrollee and are covered under a pharmacy benefit. The provisions require that step therapy protocols established by carriers must meet certain clinical review guidelines. There's also a requirement that carriers have a process to sort of override step therapy determinations. So there's a built-in process for exceptions to step therapy. The law requires those exception requests to follow the same general timelines as prior authorization requests. So if someone requests an exception from step therapy protocol, the carrier must generally respond within 72 hours or 2 business days, whichever is less. I also wanted to note that the committee might recall your consideration of LD 523 earlier this session, which would require implementation of real-time prior authorization for prescription drug requests. So some of the questions that were asked at the public hearing was whether or not the bill as drafted was necessary, given the current provisions that I just outlined. And then there were also some suggestions about clarifying the scope of the bill, defining what a serious mental illness is, that there's a definition in the original bill as drafted. And then sort of as a technical issue, the bill would enact a new provision in the prior authorization law that applies to both prior authorization and step therapy. So it was suggested that perhaps that should be separated and address those provisions in statute explicitly. And then there were some additional questions raised about the treatment of prescriptions for behavioral health differently than other prescribed medications. I'll stop there. I did also share yesterday that a proposed amendment from Senator Stewart to make some changes and clarifications in response to some of the issues that I just identified. And I'm happy to pull that up for the committee if you're interested in seeing that on the screen as well.
Yeah, why don't you do that, Colleen? Thanks.
Sure. And I have to find it. So hold on one second. I didn't have it. I thought I had it up, but I didn't. So I just gotta find it real quick. All my stuff. For some reason, I can't find it. So hold on one second. Or you could talk while I pull it up. I'll pull it up when I find it. I'm having a technical issue now.
Okay. Are there comments from the committee? Representative Tepler.
Thank you, Madam Chair. I'm of 2 minds about this bill. On the one hand, I really am not happy when we have a situation where insurance companies or pharmacy benefit managers step between a patient and a doctor. That's very uncomfortable. On the other hand, I am not sure that allowing a general practitioner or family medicine doctor to prescribe psychiatric medications for serious mental illness when they might be influenced by a drug rep's education routine is necessarily a great idea. So I worry about that a bit because I think the influence of the pharmaceutical industry is very strong on physicians at times, particularly on family practitioners. And I'm still kind of in between and betwixt on this bill and would love to hear some more from other members of the committee.
I'm ready to share whenever you want to.
Okay, let's look at the amendment really quickly, and then Representative Melrano, I'll come right back to you.
Sorry for interrupting, but
that's fine.
So just to run through Senator Stewart's amendment that I distributed yesterday, it would clarify the title, and it would, with regard to prior authorization, it would sort of separate out the two provisions in the appropriate places. But with regard to prior authorization, it would make a change to state that a carrier must approve a prior authorization request for the prescription of formulary medication, so medication that's on the formulary, covered by the carrier, used to assess and treat an enrollee's serious mental illness. And there is a definition in the statute. There is also an authorization for the superintendent to adopt rules that was in both the bill and the amendment. And then it puts in the provisions related to step therapy specifically, it adds an category of eligibility for a step therapy override determination to be the prescription drug selected by the enrollee's mental health care, the enrollee's healthcare provider is intended to assess or treat the enrollee's serious mental illness. So it provides a specific exception or in the step therapy protocol, and then makes that clarification with regard to prior authorization requests. It requires carriers to approve those requests for on formulary drugs only. Stop there.
Representative Melrano.
Thank you, Madam Chair. Yeah, just wanted to quickly agree with Representative Tepler that, of course, the pharmaceutical companies do have a great amount of influence, not only in the medical system, but in perhaps our committee even. And for example, the lobbyist for the pharmaceutical company, Synovian, it's Synovian, the pharmaceutical company that would really like to see this bill pass, has no fewer than 4 psychiatric medications in their pipeline, meaning in various forms of development. So those, when they come out, of course, they'll be very, very expensive. Carriers won't have the tool to help keep costs down. Additionally, we didn't hear from psychiatric prescribers that this is a problem. We did not hear from one psychiatric prescriber that this is a problem, nor patient. We did not hear from the American Psychiatric Association that this has been a problem, that this is one of their priorities. I think, yeah, also the Bureau has received no complaints regarding step therapy for psychiatric medication. I'm concerned if this bill passes, the effect it will have on, again, still, I should say, increasing healthcare costs. Yeah, so I'll stop there. Thank you.
Thanks, Representative Melrano. Oh, Senator Stewart, I moved to a strange part of the Zoom call that I'm not usually in, so that threw me off there for a minute. All right, Senator Stewart, go ahead.
Thanks, Madam Chair. I just wanted to say that there was some pretty, I thought, compelling testimony that was provided by folks who, at least one, about for instance of why a change like this would be beneficial. That is it is on the website. To that end, though, I certainly empathize with the concern about the rising costs of health coverage, particularly pharmaceutical medications. But in the space that we're talking about, failing first isn't necessarily an option. Failing first would mean somebody's going to jail, right? Or somebody's going to the hospital. And I think anytime that we can improve those health outcomes and put patients first, that should always be the goal. Certainly cost is a critical component in that. And to the extent that we can mitigate that, I think the amendment captures that to the best that we possibly can in these pretty few and far between instances, but ones where failure means catastrophe. And that's really what we're trying to resolve here with this. So appreciate the comments of folks that have spoken before, but did want to bring that up because I do think it's important to know.
Representative Malrano. You're waving it off. Okay. Representative Arford.
Yes, I will be. I've heard the comments, I've heard the testimony, and I will be supporting this bill. I received a very compelling email from a young woman who serves this population at a facility in Portland. And she said that withholding the medication that the provider felt was best suited to the patient because of the need for the fail first policy, which is also called step therapy, has in her mind caused great damage to this population. And regarding to testimony, we did receive some very compelling testimony in support of this bill from NAMI. And they literally said that life with mental illness for the 1 in 4 Mainers can be a complex and difficult journey. And she said that by eliminating step therapy or fail first policies, this committee will be providing life-changing and potentially life-saving policy. So I think the support is out there in the community that's receiving these medications for this bill to pass, and I will be supporting it.
Representative Morris.
Thank you, Madam Chair. I ordinarily would have a hard time with something like this because I am ordinarily someone that does not like to get too involved in this sort of thing when that are there to try and hold costs down. But this bill only applies, as I read it, to people with very serious mental illness, and I unfortunately have seen this with people that I have known that have some serious mental illness issues, and I think this is it. Particularly, I've seen the way their families struggle with it, and if this is one small thing we can do, because it only applies to those with serious mental illness, not with something that's not considered as serious a mental illness, because I have seen the struggles, both of the individual and the families with some of these people when they decide to stop taking their medication. And some of the reasons they may not take the medication is they don't like the side effects, or they feel like they're doing better. And so for those reasons, I will support it in this case, because it is, I think, a fairly limited scope for people with very serious mental health issues.
Thank you, Representative Morris. Representative Tepler.
Thank you, Madam Chair. And I just, in response to some of the comments that Representative Arford made, I want to be very, very clear that this committee has dealt with issues around prior authorization and step therapy in the past, and that in fact we have in law some exceptions to step therapy that are fairly broad, and that I think physicians can use to drive through some of the issues that are presented by what has been discussed. And so I think I'm going to be opposed to this bill. I feel like it does, as Representative Malrano said, open up the door to us adding a series of conditions, particular conditions like mental illness or cancer or whatever, to our current step therapy protocols, and that concerns me because eventually what we've got in there, which is a form of cost control for pharmaceuticals, is going to become not worth the paper it's written on.
Representative Evans.
Thank you, Madam Chair. I want you to know I will be supporting this bill. I know many people have worked on prior authorization over the years. It hasn't gone anywhere. It's not going to go anywhere anytime soon. When you're dealing with patients who have significant mental illnesses, you don't want to go manipulating their medications. The primary care physicians that I know of that work in my hospital here, they will not initiate medications without consulting with an appropriate psychiatrist to manage that, to get an evaluation of that patient. Periodically, once that patient has been started on medications, then the psychiatrist will see them periodically on a regular basis. So I don't want people to think that the primary care physicians are just out just prescribing medications. There's have an appropriate moral and ethical responsibility to take care of patients. And when it comes to mental health issues, I don't think that we do as much as we can do. And I think this allows us to do something. So I will be supporting this bill.
Thanks, Representative Evans. Are there any additional comments? All right, I'm going to look for a motion from the committee. Senator Stewart.
Thank you, Madam Chair. I move ought to pass on LD 1268 as amended with the amendment that's provided to Colleen.
Okay, is there a second? Seconded by Representative Arford. Is that your second, or are you making a comment, Representative Arford? It's a second. Okay.
Much like
we can't hear you.
I would like
the second.
Thank you.
Okay, great. Is there any further discussion? All right, the clerk will call the roll.
Representative Quint, absent. Representative Connor.
Yes.
Representative Blyer.
Yes.
Representative Morris.
Yes.
Representative Matheson.
Yes.
Representative Evans.
Yes.
Representative Arford.
Yes.
Representative Melrano.
No.
Representative Brooks.
Yes.
Senator Stewart.
Yes.
Senator Brenner, absent. Representative Tepler.
No.
Senator Sanborn.
Yes.
9 yes, 2 noes, 2 absent. We have a minority report.
Minority report is ought not to pass.
Great. Okay, so moving on to LD 738. This was a concept draft brought to us by Representative Warren. I don't see her in the work session. I don't think she's been here today. So this concept draft talks a bit about the Office of Health Equality. Is that what it's called, Colleen?
I think it's equity, health equity.
Equity,
Want me to
right?
share the
Yes,
analysis?
it would be equity. Sure.
I can, let me see. Oh, you know what?
Very quickly. I don't think we want to spend much time on it. So why don't, you don't have it open. Why don't we just
have it open?
Yeah, so I guess I would just say I don't think that it that the proposal has a clear relationship to sort of all the moving pieces of the context on which Representative Warren is trying to make a positive change, particularly this committee's earlier work this session with regard to health disparity data in Representative Tepler's LD 274. And just the fact that the MHDO exists and that it is going to be tasked with collecting health disparity data. And so with that context in mind, I would move ought not to pass. Is there a second? Seconded by Senator Stewart. Is there any further discussion? All right, the clerk will call the roll.
Representative Quint, absent. Representative Connor.
Yes.
Representative Blyer.
Yes.
Representative Morris.
Yes.
Representative Matheson.
Yes.
Representative Evans.
Yes.
Representative Arford.
Yes.
Representative Malrano.
Yes.
Representative Brooks.
Yes.
Senator Stewart.
Yes.
Senator Brenner, absent. Representative Tepler.
Yes.
Senator Sanborn.
Yes.
11 yes, 2 absent.
Great. Okay, the next bill is LD 1311, and that is Representative Evans' bill. Colleen, why don't you pull up the analysis? We'll do that one quickly.
This is actually one we've already talked about. We tabled it
Oh,
to
good.
give Ms.
Okay.
Grundy and Mr. McCabe some additional time to work on some of the language. And I'm not sure if either one of them is here to update you, but
they aren't here, but I have an update.
Okay, good. I was gonna say I did get an email update, but I'll defer to you, Senator Sanborn. So.
Yeah, I got to speak with Ms. Trundy yesterday, and they had Mr. McCabe and Ms. Trundy had spoken and had come up with sort of a plan that I think they were both more or less happy with, which was that we would strip out all of the language with regard to sort of voting elements of the bill and just keep the name change aspect of it. So because both the DAFS folks as well as the commission labor side folks were happy to have the name changed to reflect, I think, employee health and wellness or something to that effect. So we would keep those name changes, update the statute in that way, and strip out the other language, and then send a, and I'm quoting Ms. Trundy, strongly worded letter to DAFS, encouraging them to continue working through a consensus model of decision making with the Employee Health Commission, and indicating that we think that is the strongest way for them to proceed. So that was the update from Ms. Trundy. Representative Evans, go ahead.
Thank you, Madam Chair. And I received an update from Mr. McCabe. Said, and I think that both sides are happy.
Great. Okay. So I would move ought to pass as amended with just the name change, and that we would send a letter. So, okay. Is there a second? Representative Senator Stewart has seconded, and Senator Stewart, go ahead.
Thank you, Madam Chair. I have a question. I don't mind seconding it, but I was wondering, we didn't caucus the, just trying to do this on the fly. We didn't caucus the amendment. If we could take just a second, just to confirm, perhaps we can do that.
Do you want to just confer like on the phone while we're sitting here? Yeah, no problem. We'll hold.
All right, thanks.
Go ahead.
All right, I think we're all set, Madam Chair.
I need to unmute myself. Okay, great. Representative Morris, go ahead.
Yes, I just further clarification. So just looking to change the name to the Office of Employee Health and Wellness.
Yes.
Okay. And something about a letter was also mentioned, just to encourage them to continue to work together to build consensus is what we're trying to do. Okay. Okay. I think we can be okay with that.
Great. Any further discussion? All right, seeing none, the clerk will call the roll.
Representative Quint, absent. Representative Connor.
Yes.
Representative Blyer.
Yes.
Representative Morris.
Yes.
Representative Matheson.
Yes.
Representative Evans.
Yes.
Representative Arford.
Yes.
Representative Melrano.
Yes.
Representative Brooks.
Yes.
Senator Stewart.
Yes.
Senator Brenner, absent. Representative Tepler.
Yes.
Senator Sanborn.
Yes.
11 yes, 2 absent.
Great. We have one more bill on our list today. It is LD 1661, which was brought to us by Joe Perry, Representative Perry. And I think Representative Blyer would call it the half house insurance bill. I'd never heard of that term before, but it's certainly evocative of what we're talking about. I'm not sure it's worth going through the bill analysis.
Shared it.
I think
I
that
think
we
answer any questions, but yeah.
Yeah, so I think we all heard it. I think we all kind of had the same response that the insurance bureau did, which was, I'm not sure how to fix this, and I'm not sure it can be fixed. If anyone has further comments beyond that, please let me know. All right, so I'll move ought not to pass. Is there a second? All right, seconded by Representative Blyer. And is there any further discussion? All right, the clerk will call the roll.
Representative Quint, absent. Representative Connor.
Yes.
Representative Blyer.
Yes.
Representative Morris.
Yes.
Representative Matheson.
Yes.
Representative Evans.
Yes.
Representative Arford.
Yes.
Representative Melrano.
Yes.
Representative Brooks.
Yes.
Senator Stewart.
Yes.
Senator Brenner, absent. Representative Tepler.
Yes.
Senator Sanborn.
Yes.
11 yes, 2 absent.
Great.
Sorry, Tori.
Okay. All right. So I think that brings us to the end of our work session today. I think it was highly successful. We've only got one bill on the table from today, and even two. We have two. What else did I table, Colleen?
1463, which you never even talked about.
Oh, right.
Yeah.
But that was.
But you might not even
postponed.
consider that. Yeah.
No, I didn't consider that because I had never intended to get through that today once
Right.
I realized how many bills we had on the docket for today. So I'm super pleased. I enjoy working so much with all of you in this committee, because we voted a lot of bills today, and even a number of divided reports, and I think only one was along party lines. So I think that's the sign of really good legislators who are really digging in and really bringing everything to their work. So thank you so much. Okay.
I don't have any language you've used, but I
don't have
will
anything else.
No, I have some on Thursday for you. And
Okay.
then the only scheduling issue is to note that we've reserved time for a 10 o'clock presentation and public hearing on a bill that we expect to be referred to the committee and advertised, which hasn't technically been done yet. The rest of the schedule is advertised to start at 11. So just plan on starting at 10.
Yeah, and yeah, there will be another bill. We
Yeah.
will be starting at 10.
So that's the only scheduling thing, because right now I think the weekly schedule says to be determined at 10, but I think the intention is that that will be filled.
Yep. And then there'll be more work sessions scheduled for the afternoon.
Yes,
Pardon
and
me,
you want to
as
add
well.
on LD 791 for Thursday?
Mhm.
And what about 1463, or hold off still on that?
No, we should probably put that on for Thursday, I think. And then, yeah.
Okay.
We'll let folks know if we wind up not thinking we're going to get there, depending on how long how long the hearing in the morning takes.
Yep. And then there's 3 other bills for public hearing as well scheduled for Thursday, in addition to the new bill we're expecting. So, and we'll add those 2 work sessions, and there might be some language reviews, and we'll go from there. So thank you.
Okay, sounds good. And we'll see everybody tomorrow in person at the Civic Center. All right. Have a wonderful afternoon, everybody. Take care.
You too.
Thank you.
Thanks, Colleen.
Oh, you're welcome. See
And
you Thursday.
thank you, Sabrina.
Yes, thank you, Sabrina. Sabrina, I'll give you a call and we can go over or you can call me about the daily. Whenever you.
Sabrina, can you still hear me?
Yes.